And the clerk will call the roll.
Mr. President, Mr. Chairman.
Okay, thank you. Before making some announcements of how we're going to handle it today, there are a couple of simple requests, and what I'm going to do is, at the request of the patron, Senator Cosgrove, is to have Senate Bill 359 involving deeds of gift go carry over for the year with instructions that they get together and try to come up with something, okay? So Senate Bill 359 will go by for the year. Do we have to have a vote? All right.
I'll move and carry the bill by.
Okay. All in favor, say aye. Vote aye. All opposed, vote no. Okay.
We only have 7 votes. 7-0.
All right. 1, 2, 4.
Voice goes here.
Yeah, boys go vote.
Okay.
3, 4, 5, 6. We have 8 people here, don't we?
That's that bill that requires a title search every time you do a deed of gift.
Yeah. Yeah, so we need another vote.
Wait. I have cleared it. Can you vote me on something more special? No, it does come by. I close the vote.
Or open, strike the vote. Let's do it again. All in favor of the motion to carry it over for the year, vote aye.
Ayes 8, no 0.
Okay. And
75 bills
I'm
left.
also moving that we carry over for the year Senator Boysko's bill, Senate Bill 660, carried over for the year. All in favor, you can vote, second?
So moved.
All
Second.
right. All in favor of the motion, vote aye.
I'm not there yet.
Okay, not there yet. And where's Senator Chafin? We may need your vote, Senator Chafin. It's Senate Bill 660 to go carry over for the year. Okay. Ready to vote? Okay, all in favor, vote aye.
Ayes 7, no 3.
703, the motion carries. Okay, now, before we get started further, I'm going to ask, Senator Boysko has some people here on a Good Samaritan bill. It's Senate Bill 667. We'll let them have that hearing and take care of that. But after that, we're going to put the agenda to several different blocks. The first block will be the subcommittee reports. Second block will be bills with fiscal impacts. The third block will be the remaining bills. And any bill that is passed by for the day has no guarantee of being heard on Monday. And Monday's our last meeting date at 8 o'clock Monday morning or ODOC 30, whichever we have to do. And so at this point, I'd like to ask Senator Boysko, because she has some people flown in to speak on Senate Bill 667, the Good Samaritan Bill.
Mr. Chairman and members of the committee, thank you very much for accommodating this. SB 667 is what we call a Good Samaritan bill. And before we get started, I have a line amendment that was requested by the Virginia State Police.
Mr. Chairman, the amendment is after line 41, which is the end of the bill. It basically inserts subsection E, no law enforcement officer acting in good faith shall be found liable for false arrest if it is later determined that the person arrested was immune for prosecution under this section.
I'll move that amendment. Second.
Okay, moved and seconded the line amendment. All in favor of the motion, say aye.
Aye.
All opposed, no. Okay, motion carries.
Okay. Virginia's death toll from opioid overdoses continues to rise despite state and local government spending millions of dollars to make naloxone available. More than 1,500 people died just in 2019 in Virginia from drug overdoses. More people are dying from overdoses in car accidents in Fairfax County. So I'm asking you to pass this bill for 3 reasons. First, in Virginia, friends often do not call for help for fear of being arrested. Under current law, both witnesses and the person overdosing may be arrested and prosecuting. Second, in an overdose emergency, every second matters. Data shows that bystanders are 3 times more likely to call 911 when they know that there is a safe reporting law, which is what this bill would do. As you will hear from supporters here today, safe reporting will save lives. Third, we need to stop criminalizing those who are seeking urgent help for themselves and for others. Today, I'm joined by substance abuse advocates, overdose survivors, and family members who have lost loved ones. Many of the supporters have written statements to committee members, which I'm sure you all have in your packets. And I hope it's the pleasure of the committee to report SB 667 to the Senate floor.
Okay. Is there any people who would like to speak in favor of it? Thank you all for coming.
Yeah.
And we do have a limited time, so go ahead.
Chairman Edwards and members of the committee, and Senator Peterson, who's my senator, thank you for giving me this opportunity. I'm Mary Ann Burke of Change Addiction Now, a nonprofit that, among other things, provides evidence-based information about addiction to the public. As you know, the overdose rate has gone up in Virginia. I'm going to skip ahead because Senator Boysko already said some of these things. Virginia and Utah are the only 2 states in the United States that have this minimal protection of affirmative defense. And it's only after the person gets arrested. And there's a lot of evidence that it's due to this interaction with the police that keeps people from calling for help.
Mr. Chair?
Yeah, Senator Peterson.
And Mary Ann came to my office, and we've not only talked in my office, we also talked at a meeting about a year ago. I strongly support this. I think it's a great idea. I don't know if there's any opposition, but I hope we move forward. This was my bill in 2015, and
Right.
it's taken to the next logical step.
Right.
So
Okay.
I know we got a lot of bills today. I'd like to move
Okay,
the report.
I would just like to show you, make a couple of points. The next one
go
is
ahead.
that these are the states that have immunity
Okay.
or greater. Some have extremely progressive immunity for
43%.
everything. So I just wanted
43%, is
to,
that
Don't talk
right?
your way out of a victory.
Yeah, 43 states have some immunity, is that right? According to what I'm reading.
have what immunity? I didn't
Yeah,
hear.
Right here, 43 states have some limited immunity, according to what I'm reading.
No, this is, this is,
Mr. Chair, can I just move to report
Yeah,
this
no,
bill?
this is
Go ahead.
immunity. We currently do not have
Okay,
immunity.
okay.
We have.
We're going to have it after this vote.
You have some
Supporting the
people,
bill. Thank you.
step up
Thank you
very
all.
quickly and say your name and why you support the bill very quickly. Each one of you, if you'd like to, you're welcome to. You got 2 minutes.
John, we're good.
I know, you got 2 minutes, they come already.
Okay, my name is Alan Lewitis. I'd like to talk about my daughter, who is a heroin addict. She's a recovering heroin addict, recovered for almost 4 years now. I'm very proud of her. She has battled this terrible disease. She actually now has a very good job. She owns a house. She's a very active member of her community. 5 years ago, we almost lost her to an overdose. She was in a house with some other users. She had an overdose. They tried to resuscitate her. They failed. They brought her outside the house, laid her on a lawn, and left her. It's because they were afraid of becoming prosecuted if they reported it to the police. This is common. We were lucky, though. She survived. I know many parents whose children did not survive under very similar circumstances. The Good Samaritan bill will save, or could have saved, some portion of these deaths, maybe many of them, because this is such a common practice in the user community, ignoring the police and so forth.
Okay, thank
So,
you. Thank you.
yeah, I just wanted to say that I think the bottom line is it will save lives.
Good, thank you. Yes, next, sir. Thanks for coming.
I'm John Shenholster, President and co-founder of the McShen Foundation. We support this bill, and I just want to add that this is evidence-based, data-driven proof that this bill will reduce deaths in Virginia
Good,
during this
okay.
crisis.
Good, thank you for coming, and yes, sir, your last speaker, or two more, real quickly.
My name is Michael McDermott. I'm from Maidens, Virginia. I suffer from a disease for which there is no known cure. However, it can be arrested at some point, and recovery is then possible. And I've been in recovery from substance use disorder for over 28 years. This bill has very good intentions, and I don't mean to be the fly in the prom punch bowl, but the protection that it's giving to the overdose victim, I don't think is a good idea.
Okay, you're against the bill.
It's a
Okay.
good bill, it's got good intentions. I think we want to protect the person to make the call, but we have no guarantee when that overdose victim is treated by EMS or at a hospital that they're going to find recovery.
Okay.
You know, if they're on a probation violation, it should be violated, they got a better chance of finding recovery while they're incarcerated.
Thank you, we
So I'd like
appreciate
to see some substitute language
Okay.
that only protects the person making the call. Thank
Okay,
you for your
all right.
time.
Okay, next, real quickly.
Hi, hello. My name is Michelle Ross, and I'm very proud to say that I am Julia Crabb's mother. On the morning of November 14th, her father woke me up at 3 o'clock in the morning and uttered the words that no mother wants to hear, Julia's dead. What I learned was that Monte Nicholson FaceTimed her brother, he was 19 at the time, at 1:07 a.m. to say that she had overdosed. My son's response was, "Why are you calling me? Call 911, take her to the hospital."
Yeah.
My son called his cousin, who then took him to Ashburn and Nova, where Monte Nicholson and Kyle Collins were waiting for family to arrive. What is a matter of public record is that Kyle called Rodney Hearn to tell him what happened and to meet them at Monte's house. Rodney was on his way from Fairfax to Monte's house in Ashburn when he received a second call from Kyle to meet at the hospital. The time difference is 30 minutes between phone calls. Monte Nicholson lives 6 minutes from Inova Ashburn. An ambulance would have arrived sooner and prepared had they called
Do
911.
you think this bill would help?
I do.
Okay.
I just a little bit left. What stopped them from calling 911, I don't know. I do know Monte's lawyered up the next morning and has made no formal statement to me or my family.
Mr.
Okay,
Chair,
all right.
I apologize.
Yeah, that's okay.
I don't want to be rude, but I
But the bottom line is my family will never know
Right.
if it would have made a difference to call 911. And
Mr.
we
Chair,
were
I think-
denied that opportunity by them
Mr.
not
Chair.
making that phone call.
Okay, thank you very much. We appreciate your comment. Is
Thank
there a
you.
motion?
Yeah, I moved to report the bill. I think this is a very good step towards
Okay. Is there a
Mr.
second?
Chairman.
what we tried to
Is
do
there a
5 years
second?
ago.
Mr. Chairman.
Yeah, Senator Overchain.
Do the Commonwealth's attorneys have a view on this?
Is there anybody in opposition? Okay, the motion's been made.
Mr. Chairman?
Yes.
I see.
Yes, Senator McDougal.
Mr. Chairman, I would like to ask, I understand the conversation around the change from arrest to affirmative defense.
Right.
But I want to focus on number 4, item number 4 in B. So with the way it is currently, if the evidence was obtained as a result of it, this is said would have been obtained only. So who are we trying to stop with that change? In number 4.
If I may, Mr. Chairman, my name is Catherine French-Jaworski, Chief Appellate Counsel of the Virginia Indigent Defense Commission. I'm also a member of the Governor's Advisory Committee on Opioids and Addiction, and I'm also a former public defender. In response to your question, by doing it where there's no arrest or prosecution,
Mr. Chairman, that was, my question was not that. My question
Senator
was,
McDougal.
in B number 4, it says, currently the law is any evidence obtained that was obtained as a result of this is not used. Now we're changing it to would have been obtained. So if you go in, and my question, and maybe this is more appropriate for Mr. Benjamin, if somebody ODs, officer responds, finds a bag of heroin, and that heroin is linked back to a distributor and that's got bad fentanyl causing the deaths, could that evidence then be used because it's prospective, not, because it would have been only as a result of that?
What line are you
call.
referring to?
Mr. Chairman,
I know. What, 33 and 34, is that it? Okay.
it's
Wanna make sure
section
everybody's on the
B,
same-
number 4.
Okay.
So I'm trying to ask, why did we change the was to would have been only?
Okay. Yeah, Senator McClellan.
Mr. Chair, I don't know if this answers, I think this answers at least the scenario he gave. 4 only refers to offenses that are enumerated in the section. So 4 is only applying to an offense for the unlawful purchase, possession, or consumption. Possession, intoxication in public, possession. So as I read it, if in your scenario, the evidence is evidence that goes back to who sold it or what's in it and did somebody contaminate it, it could be used for that because that's not something enumerated in this section.
Okay. Any other questions? All right.
I think we have a pending
Well,
motion.
Senator McDougal or Senator Obenchain? Go ahead.
I would like to know whether the Commonwealth's attorneys have a persuasion on this
Does
or
Commonwealth attorneys have a
observations
position on
about
this? All right.
Eric Olson, I'm the Commonwealth Attorney in Stafford County. I'm speaking on behalf of VACA. We have some grave concerns about the bill and the inability to provide services and treatment and follow-up, but we don't take a position on the bill.
Okay.
Mr.
All right.
Chairman.
Yeah, Senator Deeds.
And I'd like to ask Charles and Steve to look at the language on 33 and 34 and explain, help me understand why Senator McDougal's not correct in the way he reads it.
Change from what was to would have been, I think is the
Right.
language. Or does it matter?
I don't,
Mr. Chair.
Steve, just a minute, Steve.
Mr. Chairman, I think it's
Counsel.
I think it's just grammatical.
Yeah,
Mr. Chair?
yeah. Senator Peterson.
This code section was a bill I did 5 years ago, okay? So we actually wrote this, and it was amended on the House side to make it frankly more restrictive than how I originally filed it. I actually like this amendment, this bill, because it opens up from the threat of arrest, which, as Mary Ann pointed out to me when I spoke with her, is my
Okay,
constituent.
so the motion has been made.
Yeah, I
and
moved to
seconded
report the bill. I'm fine
report
with
the
it.
bill. Any discussion? Senator Marcy.
Very briefly. First of all, I tell the patron, I know a lot of people have wanted to speak, and there's a sense of urgency today. I don't want them to know it's not because we're dismissive of them in any way. There are just a lot of bills. But, Mr. Chairman, I think this bill that is patroned by Senator Boysko not only has the potential, but will save lives. And for that reason, I'm asking that we report the bill.
Are you ready to vote? All in favor of the motion to report the bill as amended? As amended. All in favor, say aye. Vote aye. All opposed, vote no.
Thank you. Thank you.
Good, thank you, Senator Boysko. We appreciate it. Thank you all for coming. We thank you very much. Okay. All right. Now we're going back to, we'll start out with the Criminal Law Subcommittee.
The Criminal Law Subcommittee met yesterday afternoon. We had 4 bills, 2 from Senator Morrissey and 2 from Senator Survell. I think we're going to do the Survell bills first. And that 489, there's a substitute. And I'd move to adopt the substitute.
Is there a second? All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Motion carries.
Okay, the substitute has basically just deals with one issue, and that is provides that a trial court presiding in a criminal case may, after any plea or trial with or without a determination, finding, or pronouncement of guilt, and notwithstanding the entry of a conviction order, upon the motion of the defendant, upon its own motion, with the consent of the defendant, or with the agreement of the defendant and the Commonwealth's attorney, defer proceedings, defer entry of a conviction order, or defer entry of a final order, and to continue the case for final disposition on such reasonable terms and conditions as may be agreed upon by the parties, or if there's no agreement, as may be imposed by the court.
Okay.
Final disposition may include conviction of the original charge, conviction of alternative charge, or dismissal of the proceedings. The statute removes the definition, or removes provisions, the substitute removes provisions regarding the definition of good cause for purposes of a nolle pros. What this bill does basically is ensure that you can, that cases can be taken, criminal cases can be taken under advisement.
Okay. The vote was 6-0.
A vote was 6-0, yes,
Okay.
and I'd move the report.
All right, it's been moved and seconded.
John?
Second. Report, yeah, Senator,
Just so I understand, and I was just trying to read it.
Norman, Senator Norman, yeah.
It does not exclusively require the concurrence of the Commonwealth.
No, what it says is the.
Okay, I've got the answer, thank you.
Okay.
He was helping.
The answer is
Scott, I
no.
didn't mean to cut you
Okay.
off. No.
Any discussion?
Mr. Chairman,
Yeah, Senator Serval.
I just want to note that the original bill had language in it that would have clarified what a Commonwealth's attorney's discretion is to drop a case, and the committee felt that it didn't belong in there because it was violate the one object rule. But I just want to note for the committee, we got a real problem in this state of judges refusing to drop cases when the Commonwealth attorney asks for a case to be dropped. And I find it offensive. And
Do you have an amendment?
and I think we need to deal with it at some point. And, you know, it's unfortunate that that got taken out of the bill, but we need to deal with it because it's becoming a problem in Portsmouth, Norfolk, Arlington, Loudoun, and I know in a lot of other jurisdictions, y'all aren't having the problem, but it's a real problem that we need to deal with.
Yeah, Senator Morrissey?
I'm going to be brief, but I echo the words of Senator Serval. The judges are not part of the executive branch or the legislative branch. They are a distinct branch, the judiciary, and it is offensive that the executive branch, the Commonwealth's attorney, moves to do something, and the judges refuses to do it.
Okay.
So,
And I would just, Mr. Chair, and the courts where I practice on a regular basis, I've never seen it. I've heard judges that I have a lot of respect for actually say that a nolle pros is always in the discretion of the Commonwealth.
So that's not this bill, so we have a 6-0 vote.
It was this bill,
Subcommittee.
but
It
it's
was,
not anymore.
was taken out. Is a motion to report the substitute as recommended by the subcommittee. Is there a second?
Second.
All in favor of the motion, vote aye. All opposed, vote no. Okay, the motion,
Ayes 13, noes 1.
ayes 13, noes 1.
The second,
bill is reported, the substitute is reported. Go ahead.
The second bill from Senator Serval also had a substitute. And I would move to adopt the substitute.
Second, all in favor of the motion to adopt the substitute, say aye. Aye, all opposed, no. Motion carries. Okay, explain the substitute.
Okay, this bill creates a mechanism for a person who's not a citizen of the United States to vacate a criminal conviction or adjudication of delinquency other than for a violent felony or an offense that requires sex offender registration if such person was not advised of the possible adverse consequences of such conviction or adjudication on his immigration status for any conviction or offense which occurred before July 1, 2019, or if the petitioner received actual notice that he's subject to deportation or removal from the United States, exclusion from admission to the United States, or denial of the naturalization under federal law as a result of pleading guilty or no contest to such offense. And the petition is filed within 1 year after receiving such notice. The bill also provides that such person may file a petition with the appropriate circuit court, which may hold a hearing on the petition and either dismiss the petition or vacate the person's conviction or adjudication and order a retrial. The bill also provides that only one such petition may be filed. The substitute makes a very technical change in that the Attorney General will be the one that's got to respond to these petitions, not the Attorney for the Commonwealth.
Okay. Is there a second that the substitute be adopted? Okay. And then there is a Supreme Court case that says if you're not advised of your deportation possibilities, that then you could get a new trial based on habeas corpus. Is that right?
That's right, Mr. Chairman, but there's a statute of limitations for habeas corpus of
okay.
either 1 year or 2 years, depending upon the circumstances.
This extends that. Okay. Senator Norman.
Mr. Chairman, a lot of jurisdictions that I practice in, they have a guilty plea form that actually includes this provision in there. But there are also a number of jurisdictions that don't use these guilty plea forms, and the judge on the colloquy doesn't always ask the question. And how is it being resolved where the convicted non-resident defendant says, I wasn't advised of it, and the attorney says, I did advise it of him? Are we forced to a hearing?
I believe that hearing could be allowed.
Mr. Chair, I don't think we had any evidence on that point. Most of our discussion involved just general district court guilty pleas where there aren't forms. You know, I agree with the gentleman that in most of the circuit courts where I practice, and you plead guilty, it's clear, it's in black and white, and the person has to sign the document, acknowledges that he's read it, and the judge will ask him if he's read the document or had the document read to him. But we talked mostly about general district court, and the gentleman means that some judges and prosecutors are probably going to have to change the way they do business to make sure that that defendants are better advised of their rights at the time they enter a guilty plea.
Okay, any further discussion?
Mr. Chairman?
Yeah, Senator McDougal?
Mr. Chairman, so if,
Really?
making sure I'm
wow.
reading the substitute right, so maybe this is for Senator Serval. If this has no backward-looking time frame, so it could have been 30 years ago, and you would still be eligible to use this process.
Is there a time frame?
The time frame was on or before July 1, 2019. The convictions or offenses were entered, the convictions before July 1 of this past year. But the petition has to be filed within 1 year after receiving a notice.
Okay.
Yeah.
All right.
So,
Any further?
and this came out of the subcommittee 4-2, and it will have to go to finance. So my motion would be to report and refer to finance.
Mr. Chairman?
Yeah,
can I
Senator
ask
McDougal.
One other question, and I'm trying to skim back through and move. So would a person charged with a DUI third offense fall under this provision? They would be able, Mr. Chairman, my question is, would they be able to apply 20 years later for a new trial?
Mr. Chairman, can I answer his question?
Yeah, Senator Serval.
I am pretty sure they would. I don't believe that's defined as a violent felony under 17.1805, so they should be able to.
Okay. Any further discussion?
That's what I thought.
Is there a motion?
I move to report and re-refer to finance.
All right, it's been moved, and the second is to report and re-refer to finance.
Mr. Chairman?
Yeah, Senator McDougal.
Speaking to the motion. Mr. Chairman, I understand what Senator Serval is trying to do, but in these cases, some of them which could be very serious, like a felony DUI case with no ability to restrict the look back, the evidence would just not be there. So the person would file the petition. If it's granted, then the Commonwealth would be in an inability to be able to prosecute that case. The birth certificate would not be there. Likely the blood would not be there. There's no ability to retain it after a period of time. If there was a plea entered at that time, the officer might not even still be alive. Mr. Chairman, I understand what Senator Serval is trying to do and respect that, but the way this is written creates some real concerns about people being able to file a petition, and then the government is not going to be able to have any recourse to put on cases at all.
Okay.
Mr. Chairman?
Yeah, Senator Serval.
I just note for the gentleman and for the committee that part of the reason this scenarios arise, number one, is because the Supreme Court in the Padilla v. Kentucky case about 4 years ago made it clear that you cannot validly plead guilty unless you've been advised of the immigration consequences. And They refused to make it retroactive a couple years later. But part of the reason that this is a real problem is that there's a certain administration that's in place right now that has started dredging up really old stuff and decided to start using this really old stuff to take action against people who've been in this country for decades. And I've personally seen people who have been in this country and had green cards renewed, people who are here legally and had green cards renewed multiple times, where somebody decided to use some offense that happened 15 years ago as a predicate, even though they've renewed their green card. And this remedy is important so that people aren't sent back to dangerous situations. Just today, AP came out with a story that said 180 people that were sent back to El Salvador are dead, and another 70 that sent back were sexually assaulted. And so from my perspective, this simply gives prosecutors the flexibility, or it gives defendants the ability to try to slow that down and give our system some flexibility to take into account some of the policy changes we've seen federally.
Okay, is there a motion?
The motion
The
was
motion been made and
three times.
seconded to report and re-refer to finance. The substitute, all in favor, vote aye. All opposed, vote no.
I-706.
706, it squeaks out. The bill has been reported and referred. Okay.
Senate Bill 806 deals with the issue of, Senator Morsi, are you planning on presenting the bill, or do you want me to?
Yeah,
I was just going to talk about it from here.
Yeah, go ahead.
The report of the subcommittee, we had a substitute, and I'd move the substitute.
Okay, so moved and seconded, the substitute be adopted. All in favor say aye. Aye. All opposed, no. Motion carries.
Okay, this bill deals with the problem of an indigent defendant who is or charged with a felony offense or a jailable offense, and we define that as a Class 1 misdemeanor in this bill. In the substitute, somebody who's been determined by the court to be indigent, but who needs an expert. This bill sets up a process for that person upon notice to the Commonwealth to move the circuit court to designate another judge in the same circuit to hear an ex parte request for appointment of a qualified expert to assist in the preparation of the defendant's defense. At the ex parte hearing, upon a showing that the requested expert services would materially assist the defendant in preparing his defense and the denial of such services would result in a fundamentally unfair trial, the court shall order the appointment of a qualified expert. We had a long discussion of this, and at the end of the discussion, we moved to report 6-0, report and refer to finance, and I'd so moved.
Okay, it's been moved
Chairman,
and seconded to report and re-refer to finance the substitute to Senate Bill 806. Discussion?
Can I just ask the chairman of the subcommittee, the prosecutors support this?
The prosecutors were not present at the meeting. Nobody was present from the Commonwealth Attorneys Association at the meeting.
Do they, could I just ask whether they support it?
Mr. Chair.
I won't ask
I don't know.
for them to come up and speak.
I
Just-
hear somebody coming up. Yes, Senator Morsi?
Do you support it or not?
Yeah, okay.
Okay.
The answer is
They
no.
do not.
Okay.
Hold on a second.
Yeah, Senator Morsi,
Yes.
you go
Well,
ahead.
before the gentleman raised his hand, we had a witness that did come before the committee, and it said that this bill satisfied many of VACA's concerns, and he tested, that was a tall gentleman, he's
Public defender from Arlington, I think.
Chief Public Defender from Arlington, said that he had had a conversation with VACA, and that they were fundamentally in support of it, so.
Okay, all right, so go ahead. State who you are and everything.
Good evening, Nathan Green, Council Attorney for the City of Williamsburg and James City County, speaking on behalf of VACA. We did take part in discussions in another body about this bill. We did raise numerous concerns. The concerns that we raised and continued to raise in that committee, in that other body, were that this one going this broad to go to any jailable offense. We did support the ex parte hearings for felonies, but not Class 1 or Class 2 misdemeanors or any jailable offense. We did support, again, extending it to felonies, but not changing the structure that was already in place. This structure for an ex parte hearing is in place in what has been in for a decade with capital offenses. What we asked was that we use that same structure that exists and just expand it to non-capital felonies. And that was our position. We had a problem with the breadth, we had the problem with changing the process, and we had a problem with this will now, the changes from what we've been doing for the last 10 years include that this ex parte hearing, while it will be on the record, is now subject to appeal. The prosecutor or the Commonwealth will not be part of that meeting, will not have any opportunity to perfect or correct the record, and therefore, and then we will still have to face appeal issues, even though we weren't there.
Okay,
Mr. Chair,
Senator Deeds, go ahead.
We addressed the breadth issue. We took out of the language the jailable offense language, so the Class 2 misdemeanors are gone. It's only felonies and Class 1 misdemeanors. But Senator Morrissey can address the process issue because there was some concern expressed about trying to utilize the capital murder.
Mr. Chairman, I'd say a couple of points. One of the other concerns that was brought up by a member of the subcommittee was that even a Class 1 misdemeanor could affect some individuals' ability to stay in the United States, to be deported, et cetera. So that we had a pretty rigorous discussion, Mr. Chairman, regarding going to Class 1 misdemeanors because of the potential consequences. With regard to, and I beg your pardon, what is your last name again?
Green,
Mr.
just
Green,
like
I'm
the
sorry.
color.
With regard to the structural change, we discussed that, and here's what the problem is. If you keep the the structure as it is right now, it is not an ex parte hearing, it is an adversarial hearing to request an ex parte hearing, and that defeats the purpose. It was discussed that an adversarial hearing to determine whether or not you would be entitled to an ex parte hearing would divulge the defendant's strategy. So that's why we felt that the structure was needed to be changed.
Mr.
Go ahead,
Chair.
Mr. Green.
Yeah, you know, I've got all the respect in the world for VACA. I was a former member of the board of VACA. But, you know, we have subcommittees, Mr. Chair, I would argue, where this sort of exchange can take place. Subcommittee met yesterday afternoon, we made a report. And I'd reiterate my motion to report and re-refer.
Mr.
Second.
Chair.
Let Mr. Green say whatever he wants to say.
Mr. Chair.
Your Honor, Mr. Chairman, my issue with changing the process is we are expanding this to a much larger class of cases. When it's being done in capital cases, you have the best of the best as far as defense attorneys making these motions, filing the affidavits, and you can, there's a lot of trust that it's going to be done correctly.
Mr. Chair.
We've now gone to almost any Class 1 misdemeanors.
Mr.
I know.
Chair.
Okay.
I apologize.
I think I
Go
can
ahead,
take,
Senator.
I'd like to make a motion to take
Peterson.
Class 1 misdemeanors out of it. And let's just limit it to felonies. Can I get a second?
Is it moved and seconded?
Not by me.
No, okay.
Oh, well, then I'll just vote against the bill then.
Motion's made
Okay.
to take misdemeanors and seconded to take misdemeanors out. All right, any discussion? All in favor of the motion, say aye.
Aye.
All opposed, no?
No.
Sounds to me like noes have it. Would you
All
like
right,
to go on the
that's
board?
fine. Have your,
Okay, the noes have it. Okay, so.
Mr. Chairman.
Misdemeanors in, okay.
Go on board.
Okay,
Mr. Chairman.
yes, go ahead. Yes, Senator Chapin.
Yes, Mr. Chairman. So this bill is very similar to the procedure that is allowed in federal court, in federal district court. And
Federal court or?
Federal
court, okay.
Federal court. And so, you know, I like the bill that Senator Morrissey has. I would have preferred to have taken misdemeanors out and started it, and let's see how it worked with just felonies. I like Senator Peterson's motion, but it failed. But I still support the bill.
Okay, is motion made?
Motion was made to report and re-refer to finance.
Okay, all in favor of the motion, vote aye. All opposed, vote no.
Ayes 12, noes 3.
Okay.
12 to 3, the motion is, the bill, the substitute is reported and re-referred to finance. Okay.
Mr.
Senator
Chairman.
Deeds. No, I'm sorry.
Thank you,
Senator
Mr. Chairman. Having voted on the prevailing side by which we reported Senate Bill 625, I would ask that we reconsider that vote by which we recommended that it be reported and referred to
Okay,
finance.
Senate Bill 625 is moved. Motion is made to reconsider the bill. All in favor, vote aye. All opposed, no. Okay, the bill's before us again as 14 to 1.
Mr. Chairman, I'm sorry, just point of order.
Reconsideration.
Was the Senator Norton, were you on the prevailing side? I didn't notice.
I'm sorry?
Were you on the prevailing side?
I was.
I didn't notice, okay.
Okay.
I would reiterate the motion, restate the motion to report and refer to finance.
Okay. Is there, all in favor of the motion to report and re-refer to finance, vote aye. All opposed, no.
Ayes 7, noes 8.
Ayes 7, noes 8. Okay, it fails. Okay.
Okay, Mr. Chair, the last bill that, on our report was Senate Bill 811, also from Senator Morsi. We've got a substitute for this bill, too. And
Jesus.
you folks on the back row, you're going to love this one. And again, you weren't there when the subcommittee met. I apologize for that, but I'm not the one that wasn't there. Because I would move the substitute be adopted.
Okay, it's
Move the substitute be
moved
adopted.
and seconded that Senate Bill 811, the substitute be adopted. All in favor say aye.
Aye.
All opposed, no. Motion carries.
Okay, this substitute was reported out or recommended for report on a 5-to-1 vote. And this substitute is lengthy, but what it does is very simple. It authorizes judges rather than juries to determine and impose a criminal sentence. Jury sentencing remains authorized in capital cases only. And that's the bill.
Mr. Chair,
Yeah, Senator Peterson.
does a defendant still have the option of choosing a jury sentencing? Like, say they went through a jury trial and they said,
Mr. Chairman, the answer is no.
The defendant still has a right to a jury. The Commonwealth has a right to a jury. The court can order a jury trial, but the sentencing itself is done just like it's done in most other states and at the federal system.
I know how it's done, Mr. Chair.
Yeah, Senator Peterson.
Would the subcommittee chair consider a friendly amendment to leave it as an option to the defendant to have a jury sentencing? And I see a nodding head to my
Is there a
right.
motion that we have a line amendment to the, okay? Is there?
Second.
Language, okay, it's been
Oh,
moved and seconded in concept to have the
Mr. Chairman?
defendant to have the option to have
I
a
mean,
jury.
Mr. Chairman, I have spoken with at least one other individual who brought that to my attention. I am fully supportive of that being an option for the defendant to have the sentencing done by a jury. We did not get as far as drafting a line amendment, but I consider that a friendly amendment.
Okay, I would say that in the military, the defense is the only one that can ask for a court-martial with members, like a jury. The prosecution cannot. That's the way the military system works. Okay, it's been moved and seconded that the,
But,
be at the.
Mr. Chair, I'd like to ask staff,
Mr. Chairman, I think that the amendment could be made easily on line 517.
okay.
After the word "except," insert "when requested by the accused,"
Okay.
and "when the accused is found guilty of capital murder."
Okay,
I'll move that, Senator Peterson's. Second.
all right.
And the amendment should also include, we would also need to go through the bill and make sure that there's no place else that we need to make a change, but that's the essence of the amendment.
Could staff read it one more time slowly and tell us the line and the word that it comes after?
Sure, starting on line 517, after the word "except," insert "when requested by the accused," and the next word would be "when." And so that complete sentence would read as follows. The deliberations of the jury shall be confined to a determination of the guilt or innocence of the accused, except when requested by the accused and when the accused is found guilty of capital murder.
Okay.
Or, that should be an or instead of an and.
Okay, we got it. Want to read it one more time? On 517?
517. Yeah, it's going to require more. The deliberations of the jury shall be confined to a determination of the guilt or innocence of the accused, except when requested by the accused or when the accused is found guilty of capital murder.
Okay.
And we may tinker with that, but that's the language.
All right, it's been moved and seconded that line item amendment be adopted. Any discussion? All in favor of the line item? Okay, guys, hold it down here. All in favor of the motion to adopt the line amendment, vote aye, say aye. All opposed, no. Okay, the line amendment has been made. Any further discussion?
Mr. Chairman.
Been moved and seconded to report the substitute as amended. Yes, Senator Obenchain.
And I recognize that the Commonwealth's attorneys were not at the meeting, but especially in light of the fact that we have a 36-page substitute that's been amended, I would ask that the Commonwealth's attorneys come share their thoughts if the chair would entertain that.
Absolutely. Go ahead.
I think he went out of the room to
All right.
make a call.
Well, I'll tell you what.
Well, then,
go
could
ahead.
this go by temporarily?
Go by temporarily. Okay. All right. So, Senator Deeds, are you finished? Except for
That was a report, Mr. Chair. I'm going to have I got to go take care of the bill and other.
Okay. All right. Now we move on to the Civil Law Subcommittee. Senator Peterson.
Mr. Chair, I'm going to start with Senate Bill 229. That was my bill, had to do with signature defects on pleadings. It's basically an amendment to Section 8.01-271.1 of the code, which requires every pleading that's filed in court to be signed by the attorney of record or the party pro se. This bill simply says that where a pleading is not signed, that it is voidable. However, that has to be raised timely. It has to be raised within the time that's referenced in the bill. I believe it was 21 days. And if it's not raised timely, then it's effectively waived. So it just fills in a gap on Section 8.01-271.1. The bill was reported on an recommended for reporting on an 8-0 vote, and I would so move.
Okay. Any discussion? All in favor of the motion, vote aye. All opposed, no. It's okay. Bill, okay.
Ayes 15, no 0.
15-0, the bill is reported. Okay, second?
Okay, next bill is Senate Bill 261, patroned by Senator Chafin. Yet another one of Senator Chafin's bills I strongly support, but it went through accounts, deals with accounts filed by fiduciaries and reports filed by guardians, and just added a subsection D that the account has to be filed under oath. We had a discussion as to whether or not there should be a criminal penalty if there was a false statement, or whether or not there should be a civil fine. And a very persuasive case was made by Senator Chafin that you'd rather have a civil fine, otherwise the party would take a Fifth Amendment and basically cut off the investigation. So we recommended reporting on a 7-0 vote. Was there an amendment? I'm sorry. Yeah, we incorporated Senate Bill 308 from Senator Stanley. So do I have to make a separate motion to roll that in?
Yeah.
Okay, so I would make a motion to roll in Senate Bill 308 with Senate Bill 261.
All in favor, vote aye.
Aye.
All opposed, vote no.
Ayes 15, no 0.
And then,
Okay, the bill, been rolled into, is there a motion?
and then the Senate Bill 261 is in front of us, and I would make the motion to report that bill.
Is there a second? Moved and seconded to report the substitute to Senate Bill 261. All in favor of the motion? Go ahead. You have something to say, Jeff? Jeff? Okay, all in favor of the motion, vote aye. All opposed, no. Motion carries. 15-0. Okay.
Next bill, Mr. Chair, was your bill, Senate Bill 375. That had to do with the immunity of matters of public concern and SLAPP suits. And I'm going to ask that we carry that over for Monday and give a little bit of an explanation. Okay. We had 3 different versions of that bill. Actually 4 different versions. We had your original bill. We then had a substitute. We had a substitute that was prepared by our good friend Senator Benjamin, and then I had my own substitute. We basically went with Senator Benjamin's as sort of a framework to work with, but we have to make some changes, changing it from from a demur to a special plea. And I'd like to at least have the weekend to get the verbiage correct on that before I bring it to you all. So with your permission, Mr. Chair, I'd like to carry that over till Monday's meeting, and it does not need to go to finance.
Okay. All right. Next, Senate Bill 401.
Next is 401. This was a bill from Senator Hashmi. And, okay, Senator Suravel, oh, actually, I'm gonna defer to my colleague to the right here, Senator Suravel.
Yeah, this is, speaking to the bill, Mr. Chairman, this is basically adds a subpoenaed party to the list of people who can obtain relief under our current SLAPP statute. Right now, the way a lot of these SLAPP statutes happen, somebody files suit against a John Doe and then they send out a bunch of subpoenas, and the person who has to deal with the bogus subpoena doesn't have the right to seek their attorney's fees, unlike a party. And so this just makes it clear that a subpoenaed party who gets the subpoena quashed on the grounds of a First Amendment violation can seek attorney's fees.
Okay. I would go ahead and move this bill reported, and this may end up getting wrapped into the 375, but I would go ahead and recommend we report 401.
Is there a summary of Senate Bill 401?
Yeah, it's in the subcommittee report, and basically, just Senator Suravel explains, it deals with somebody that is subpoenaed as part of a civil action, typically through a John Doe suit. If someone is doing what I call a fishing expedition suit, they file a John Doe action, then they serve subpoenas to try and take discovery as a result of that action. So it has the effect of being part of a SLAPP suit, even though they're not a named party.
Okay. Vote
I hope that made sense.
8-0 in subcommittee. Okay.
Yes.
And as a motion's been made and seconded to report Senate Bill at 401. All in favor of the motion, vote aye. All opposed, vote no.
Okay.
14 noes, 1.
All righty. The next bill, Mr. Chair, is Senate Bill 529. This is the dead man's rule. It repeals the dead man's rule. The dead man's rule is, and there's a substitute on this, correct?
Yeah, it is a substitute. The motion to adopt the substitute.
So moved.
All in favor, say aye.
Aye.
Motion carries.
Do we have the substitute?
It should be in your subcommittee packet.
Oh, okay, all right.
Okay.
All right, I can explain it very quickly. The substitute basically repeals the entire statute, which rather than trying, this is probably one of the most confusing and illogical statutes in the Virginia Code, and that is saying something. This repeals it entirely, so statements made by a deceased person are just subject to ordinary hearsay rules, admissibility rules, and we get rid of that entire statute, which all I can say is it's about time. So we had a very good discussion on that. We had a UVA law professor, Ken Sinclair, who sort of gave us the historic background on us. I didn't remember this being controversial, but it says 5-3 on the sheet, so maybe there were some no votes. But I did vote I know the majority voted to repeal it, and I would so move.
Okay, moved and seconded that the Senate Bill 529 be
Mr. Chairman.
Substitutes be reported. Yeah, Senator Robinson. Hold on, Senator Robinson.
So one of the things that the dead man statute does is it prevents somebody from getting a judgment against somebody who's dead based on uncorroborated testimony about the deceased person. Does this do away with that? So you can get a judgment on, I could get a judgment against Suravel's estate with me saying, uncorroborated, Suravel agreed to this.
Well, and Senator, Professor Sinclair pointed out the corroboration rule is one of the biggest problems in the code, and it's all over the place, and it's almost impossible to predict, and it's, to use his term, I think, irredeemably defective.
I would say, if I could answer my colleague, you have all the same, issues such as statute of frauds. You'd have all the same issues with proof. You'd have all the same issues with all of these things.
Mr. Chairman, if it is not something that is covered by the statute of frauds, I could offer my hearsay statement of the agreement between Servell and me, and since he is not there to refute it, and there's no corroboration requirement, I have uncontradicted prima facie evidence in support of my claim, and his estate may stand defenseless.
I might point out that 80% of the states have abolished it. It's not in the federal rules of evidence either.
I would also make the same point that you could have someone who abandons the country and you'd have all the same issues. And I think we can handle these situations. I've brought claims against people that were deceased or they died halfway through the litigation. And, the problem with the dead man's rule is it makes it impossible to get a judgment against the estate when you have a meritorious claim. So it is.
So, Mr. Chairman, further question. So the dead man statute's provision that exempts the statement of a dead person from the hearsay rule, that's repealed as well?
I might point out, if it's in writing, like the shop book rule, it comes in. If it's habit or something like that, it could come in. I mean, there are ways in which it could come in.
So, Mr.
Depending
Chairman,
on the case.
So if Servell had said in connection with that dispute, I absolutely never made that agreement with Obenchain, that would be inadmissible hearsay with the repeal of the dead man statute.
The rules of evidence, you understand the rules of evidence there.
I pretty much do understand the rules of evidence, Mr. Chairman.
I'm sure you do. The problem with the dead man's rule is impossible to predict.
Mr.
I've
Chairman.
never met a lawyer that really understands it. Go ahead.
Well, Mr. Chairman, I guess to the patron, has the Boyd Graves Conference recommended this?
I think back in '03 they did, if I'm not
They
mistaken.
recommended the repeal
back
of
then.
the dead man statute.
But not
in the
now.
form
Not
that-
recently. No, they've not recently. They've come up with something different.
All right.
Go ahead.
Mr. Chair, and let me just summarize, and I try cases for a living just like Senator Obenchain does. Look, at the end of the day, these are matters of proof. And there are hearsay exceptions. A statement by a party is a hearsay exception. And a statement in and of itself does not make a case. And if there's evidence to the contrary, that can be raised by the estate. All we're saying is the dead man's rule effectively says that evidence that would ordinarily come into evidence through hearsay, or as an exception to the hearsay, can't come in if a party is now deceased, which effectively gives them a get-out-of-jail-free card. And I understand they're no longer around, but that becomes a problem if, let's say you had a general contractor that worked on your house and then he drops dead, and meanwhile he took $100,000 of your money and never completed the job.
Mr. Chairman, the statement by a dead person is only admissible if it is a statement against his interests.
Not true. Not if he's a party.
It is not a blanket exemption to the hearsay rule.
Jeff, you want to say something? Okay.
Just Jeff Palmer on behalf of the Virginia Bar Association. Just to clarify, the introduced bill was the recommendation of the Boyd Graves Conference. Obviously, this is a departure from that recommendation. So we don't have an opinion on the substitute that's before you, but the original bill was our recommendation.
Yeah, let me ask you, back in '03, they voted to abolish it, didn't they?
I don't
You
have
know
those.
what?
Okay, all right.
Back in '03, I can tell you the answer to that because I was on the Boyd Graves Conference and I was elected in '03, and Senator Mims was on the Boyd Graves Conference, and he said, I think this would be a fine bill for you to carry, Senator Obenchain. And I carried it, and I walked into a buzzsaw in 2004 because it was so highly controversial, and there was such a divergence of opinion about the impact of this was going to be on litigants and the ability of the estates of deceased litigants to protect themselves. So I would just caution that I think we're doing something precipitous. It is not what the Boyd Graves Conference recommended. I would hope we would not do this in this kind of a precipitous fashion.
Well, we did have a pretty good hearing with Kent Sinclair, professor, who, as I say, thought this dead man's rule was irredeemably defective. And almost impossible to apply. Okay.
Mr. Chair, I move to report the bill if I can get a second.
Second.
All right, thank
All
you.
in favor of the motion to report the bill, Senate Bill 529, vote aye.
Ayes 9, no 6.
Ayes 9, no 6. The motion carries. Okay, moving on to the Senator.
Next one was Senate Bill 545, Mr. Chair. That was your bill on appeals from a general district court. And I think it's fair to say we had a long conversation on this, and we got wrapped around the axle on how a counterclaim is appealed. But in retrospect, I may have misjudged this issue, because if the plaintiff loses at GDC and they appeal, and it automatically brings the counterclaim with them, then their appeal by definition would require posting a bond. So I apologize, I did not, my head was not screwed on correctly, and I didn't really think through this. So we recommended continuing it to 2021. In retrospect, I think it's actually all right as it is. So we did make a recommendation to continue, but I do think in retrospect, Mr. Chair, it may probably be okay, but the recommendation was to continue.
Let me explain it. This bill came to me because of the Supreme Court decision, whereas you appeal from the General District Court to the Circuit Court, you got 10 days. And if you miss it in the plaintiff appeals or defendant appeals, and the other side doesn't know there's an appeal until after the 10 days, it's too late to bring the counterclaim or cross-claim. That's the thing. So this, if you appeal, the whole thing goes up. So it says, any appeal taken under this section shall serve as an appeal of all claims in the lower court, including any counterclaims, cross-claims, and third-party claims. That's all it does.
Mr. Chairman.
So the whole thing goes up and not just piecemeal. Senator Serval.
I understand what you're trying to fix, and I think it is a problem. It seems to me that at least the intermediate solution is that the other side, if there is a counterclaim, that the other party have an extended period to note an appeal from the day the appeal is filed. And that would deal with where you can't get sandbagged, where somebody files an appeal on the 10th day at 4 p.m. and you find out about it too late to appeal your own case. It seems to me that's the solution in the short term.
The problem with that is simply, so you're out of town for 5 days. The original proposal was 5 days, but if you're busy, you don't find out till you get back after a week. It's too late.
Yeah, Mr. Chair, and again, the subcommittee punted on this, but I actually, now that I've seen it with fresh pair of eyes, I think it's just easier to have the counterclaim go up with the appeal if the plaintiff chooses to appeal the case.
We're going to offer the substitute, which is, I got a copy, thank you. The substitute is just that.
Saswell?
Okay, I'll move the substitute. Is there a second?
Second.
All in favor of the motion, say aye.
Aye.
Okay, we have a substitute. And again, all it says is, any appeal taken under this section from the, say, General District Court to the Circuit Court shall serve as an appeal of all claims in the lower court, including any counterclaims, cross-claims, and third-party claims. So it all goes up. Nobody gets surprised. Okay? And that, again, apparently the courts have been all over the place on this. And so this would clarify it.
Mr. Chairman.
Senator Chafin.
Yes, Mr. Chairman. I'm looking at this, and I like the idea of it all going up. We were trying to do something in a fast fashion the other evening in subcommittee, and I'm wondering if you would entertain an amendment that maybe staff could put on this bill that would say something to the effect that any party's action who would have required an appeal bond shall also be required to file an appeal bond, shall also be required to perfect their filing. because that was one of our stumbling blocks.
Right.
Was making sure that the clerk's office and the general district court judges knew what exactly had to be perfected and how it had to be perfected for appeal.
The appeal bond is in a different section of the code, and the question is to I think it says that basically, but.
Mr. Chairman.
Yeah, Senator Shervill.
I'm just, again, this is the scenario that keeps me up at night on this bill. Plaintiff sues, gets and defendant counterclaims. Plaintiff takes a judgment for $25,000. Defendant's counterclaim is dismissed. The way I read this, the defendant, why can't the defendant note an appeal and the whole case goes up? They note appeal to their counterclaim, but not the judgment. Now the whole thing goes up and they don't have to post a $25,000 appeal bond.
Jeff, would you like to weigh in?
Just to put some context around the original bill, the Boyd Graves Conference made a recommendation that was similar to what your original bill is. There's a bill on the House side that is their recommendation, but the issue that they were contemplating was a writ of possession and an unlawful detainer action that are actually two separate cases, but if they're going to be appealed, that same scenario should apply. So this wouldn't apply because it just talks about counterclaims, cross-claims, third-party claims. The language in the original bill was a little broader to take into account the unlawful detainer and writ of possession actions that the Supreme Court cases that were brought up dealt with.
This wouldn't be a cross-claim, counterclaim, or third-party claim?
Well, the original bill was more general than that because it talked about, cases that arise from the same set of facts.
Same thing.
Mr. Chairman.
Senator Shervill.
So, let me give you another scenario. Suppose I sue somebody for a lot of $25,000 in GDC, and somebody counterclaims me. Okay, and suppose it's like they got a legit counterclaim. It's like a real case. And suppose the general district court judge screws it up, and I get a judgment for the plaintiff gets a judgment for $5,000, and the legitimate counterclaim for say $25,000 gets dismissed. Never mind, that doesn't work.
Okay.
Mr. Chair.
I think the bill is okay. It solves a lot of problems.
I actually think this bill's okay, and it's very, I'm sorry.
Okay.
Mr. Chair.
All right, Senator McClellan.
I think I'm a little confused because I'm not on that subcommittee anymore. But my understanding of the purpose of subcommittees is to work out this very discussion.
Exactly.
And there's a unanimous recommendation from the subcommittee. As someone who is not on the subcommittee, I'll be honest, all this discussion is doing is making me more confused.
Okay.
Yeah, John, let's just take this.
Go ahead. The motion's been made and seconded that the bill the substitute be reported. All in favor of the motion, vote aye. Did we adopt the substitute? Yeah, we've already adopted the substitute. Somebody who's got Creed's question.
John, sometimes you just got to let it die.
Ayes 10, noes 5.
All right. As 10, noes 5, motion carries. All right, the bill is reported, okay?
This is going to move pretty quickly. Senate Bill 640 had to do with expungement on unlawful detainers. This would be an unlawful detainer which was dismissed or non-suited, but basically went in favor of the tenant, and this was Senator Servell's bill would just allow it to be expunged. And that's Senate Bill 640, and we reported that 8-0 with a substitute. And it has to go to finance.
All right, is the substitute adopt, motion's been made to adopt the substitute? All in favor say aye.
Aye.
All opposed, no. All right, any discussion?
And I would move that we report that bill to finance,
All right,
refer to
been
finance.
moved and seconded that the substitute be reported and re-referred to finance. Any discussion? All in favor of the motion, vote aye. All opposed, vote no.
Ayes 15-0.
15-0. Okay, next.
All right, next bill is Senate Bill 641. This was a civil action for the sale of personal data. This is Senator Surville's bill. It dealt with the buying and selling of personal data by companies such as LexisNexis and other companies that basically do data mining. We got a lot of pushback on this bill from people in the commercial space that do this. And after hearing all that, it was pretty much our unanimous recommendation to go ahead and kick that bill over, or carry that bill over to 2021 with a letter to GCOTS, which Senator Surville is going to personally write.
Okay, is there a motion to adopt the substitute first, right?
I don't know, we don't need to do that.
Okay, a motion to carry it over to the 2021 session with a letter?
Yes.
Okay, all in favor of the motion, say aye, vote aye. All opposed, no.
Ayes 15-0.
Okay, next one.
The next one is Senate Bill 872. This was a guardian ad litem bill brought by Senator Marsden, and I think there's a substitute on that also.
Okay, 862, motion to adopt the substitute, moved in.
I don't remember us reporting this.
Mr. Chairman, we had a substitute from subcommittee that was language that OES had brought, but since then, I think that they have had updated language that I am happy to pass out.
Also, my recollection was we either PBI'd or carried over this bill.
I have it down that we voted 5-0 and 3, but what did we do, Kristen?
Had the guardian ad litem and
Yeah. Let's see what we got. Kristen, what do we got here? Okay.
Okay, I think then we have a substitute. We must have done some major surgery on that. Okay, here's what we did. Senate Bill 872 is the veritable shell of its original self. And we took the guts of the bill, which allowed a guardian ad litem to be appointed in a private divorce and have the state pay for it. And we basically jettisoned that and replaced that with a single sentence that simply said that in a case where a guardian ad litem is appointed in the best interest of the child, the court may apportion the cost between the parties. So in an extraordinary case where they already have authority to do that, they can apportion the cost. So you can look at me and say, isn't that already the law? And my answer is yes.
Well, then I'd move
Mr.
to pass
Chairman.
the bill by indefinitely.
Mr. Chairman.
Yeah, Senator Sherrill.
I think what the Supreme Court or Senator Marsden was seeking is that the court advance the money and then the circuit court order to pay it back like happens in general district court. And right now, the circuit court cannot order that it be advanced. They can only order a GAL, and the GAL get paid after the case is all over by the parties subject to contempt of court. And so I think that the idea is that if it doesn't work the same as in juvenile court, where the money can be advanced by the state, that it won't work in some cases. And so I think the Supreme Court had some additional language they wanted to stick in to clean it up to make it so it does that.
Okay, Supreme Court.
Yeah. Good afternoon, Mr. Chairman, members of the committee. Sandra Carrison, Office of the Executive Secretary, Supreme Court of Virginia. Just to be clear, the Office of the Executive Secretary, the court had no position on the bill. Senator Marsden had filed the bill. The Executive Secretary's office had merely attempted to come up with procedures to assist the senator in implementing should the policy of paying guardians ad litem through the circuit courts be adopted by the General Assembly. We wanted the administrative procedures to be in place similar to that which exists in the juvenile courts, which already have the authority to pay through the Commonwealth. We wanted those procedures to be streamlined and efficacious so that we could assist, and that was my effort with Senator Marsden. I also would like to point out for your consideration that circuit courts have the authority to appoint guardians ad litem in cases involving child custody visitation, and they have the authority to apportion the costs among the parties, which is what this bill is purporting to do.
Does it do more than that, such as he's mentioning the state fronts the money, or?
There is no authority to have the circuit courts order the payment through the Commonwealth, except in cases appealed through the juvenile courts.
Okay, Senator Norman, I think, had a question.
Yes, sir.
That's what I'm trying to clarify. Well, maybe I should ask the advocates of the bill. Are we seeking to have the money advanced to the guardian ad litem for the payment of the services, and then the fee can be apportioned and there's a repayment?
I think that was what Senator Morrison attempted to do, but
that's what he wanted.
He wasn't very articulate about it.
Okay, my second question is, has anybody tried to do a takeoff or a pro forma on what the cost is going to be in advancing those fees? Because the premise is that sometimes the guardian ad litems are not getting paid by the parties, therefore that premise seems portable to me.
Mr. Chairman, Senator Norman, the fiscal impact statement filed by the Office of the Executive Secretary associated with Senate Bill 872 was, I believe, about $250,000 for, we estimated about 10% of these circuit court cases. It would amount to divorce cases that circuit court judges might appoint a guardian ad litem in divorce cases in about 10% of the cases and have about about $250,000 fiscal impact. And then parents could be assessed, the cost would be required by law as well, and then repayment would be depending on if they would repay.
This bill doesn't say that there's going to be fronting, the money's fronted.
Mr.
Commonwealth, yeah. Senator Peterson.
We made a recommendation. What we reported was basically, in my opinion, basically nothing. So if y'all want to PBI the bill, please just go ahead. I hate having this conversation, which is taking time over a bill that frankly does nothing.
Does this bill do anything as far as you know?
I moved to PBI.
Just a minute. I want to sprinkle. Does this add anything to the authority?
With all due respect, the bill does not do anything.
All right, fine. Okay, I understand. I want to make that clear. All right. His motion has been made. Go ahead. Motion made to pass the bill by indefinitely. Is there a second?
Second.
Is there a second? All right. All in favor of the motion to pass the bill by indefinitely, say vote aye. All opposed, no. Okay. All right, motion carries. Okay, final bill.
Okay, this bill actually does something, so pay attention. We had sort of a fake one in there so we could get to a real one. The next bill is Senate Bill 1043, and this bill would allow, and do we have a substitute, or it's in the packet? Okay. Well, while I'm looking for it, I'm going to do this based on memory. Senate Bill 1043 was Senator Servel's bill, and this would allow a circuit court to enter an order that would consolidate cases of like factors involving commonality, numerosity, and all the other factors that we know from Federal Rule 23 into what is commonly known as a class action. And I believe 48 other states do it, and 49, 48? 48 plus District of Columbia.
Right.
And basically, this would allow, if you have like cases, to put them together and have it certified as a class in state court, so you wouldn't have to go to federal court. The substitute that we have had the Virginia Supreme Court would articulate rules, and I think we gave them a year. This would not take effect until July 1, 2021, and the Supreme Court would come back with rules by, I think it was November 1, 2020, which would effectively mirror Rule 23. They would not be more restrictive than Rule 23 of the federal rules, that effectively would allow Virginia attorneys to file class actions for the first time. If you practice law in Fairfax County, you're very familiar with the Chinese drywall cases, the Volkswagen cases, other cases where you have common fact patterns, thousands of plaintiffs, and rather than being able to combine them in one suit, you got to file 1,000 individual actions. Obviously, the advantage is if you can get a certification, you can do it as one case. Obviously, large companies don't like this, but we did vote on a vote of 5 to 1 to 2 to report this bill, and I so move.
Second.
We need to adopt the substitute. I'm sorry, adopt the substitute.
Motion's been made and seconded to adopt the substitute. All in favor say aye.
Aye.
All opposed, no. Do you have the substitute? Does everybody have a substitute? Okay, it's in the packet, okay.
Right, and so having adopted the substitute, I move to report the substitute.
Okay. Any discussion? All in favor of the, yes, Senator
Mr. Chairman.
Overchain.
Anybody here from the Chamber of Commerce who wishes to comment upon how this is going to impact our business rankings?
They testified at committee.
They loved it.
I think he's saying no, but you can interpret it however you wish. Come on.
Jeff Palmer on behalf of the Virginia Chamber of Commerce. There's a big concern that this will negatively impact Virginia's business rankings. It's very clear in the legal climate rankings that exist right now. One of the categories is the state's treatment of class action lawsuits, and Virginia is not even counted in that category because of our current law. And so if this bill passes, we will be counted in that category.
How many states have class action, do you know?
I think that's already been mentioned.
Mr. Chair.
Yeah, Senator Deeds.
And of the 48 states that have class actions, how many of them rank higher than us, or somebody has to rank above us if we're 14th in one poll and 6th in another, or whatever?
Well, in this particular category, I think we're considered, we're not even ranked in that category because we don't allow class actions.
But the overall.
And so this will be a drag on our rankings, and that's the biggest concern from the
Mr.
Chamber of
Chairman.
Commerce.
Yes, Senator Saslaw.
Hold on, Jeff.
Happy birthday, by the way.
47 states allow what this bill would do.
Class action.
Class act, 48.
I trust the representations of the senators.
Okay.
Yeah. And the current statute allows for consolidation if it's the same set of facts, of 6 or more plaintiffs, but this would allow for.
Mr. Chairman?
Yes, Senator Saslaw.
How many lawsuits would have had to been filed in the Volkswagen case?
400.
You really think that makes us a better state?
Our main concern is the impact on the business rankings and our ability to attract.
I don't think it's going to have one little, who is not going to come to Virginia? Let's face it, they got caught with their hand in the till.
Okay. All right,
Okay?
Senator
All right,
Overchain.
thank you.
Senator
Mr.
Overchain,
Chairman,
yes, go
I
ahead.
would, on this issue, probably agree with Senator Saslaw, only to the extent that given some of the other things that we're doing in other committees and passing out, this is going to have a negligible impact upon our rankings.
Okay, is there a motion? It's been moved and seconded to report the substitute of Senate Bill 1043. All in favor of the motion, vote aye. All opposed, no.
Okay.
Ayes 9, no 6.
As 9, no 6, the motion carries.
And Mr.
Senator Peterson?
Yeah, having changed the legal history of the Commonwealth, the subcommittee rests.
Okay, the subcommittee rests. Okay, now we go on to
Okay, can we
Block 2.
Can we return to the Senate Bill 811? I think we have the VACA representative back in the room.
Senate Bill, okay, we'll bring back Senate Bill 811, sentencing.
This was the little bill that 38-page substitute that made one simple change. We eliminated jury sentencing except for capital cases, and pursuant to Senator Peterson's amendment, we said, but unless the defendant chooses to be sentenced with a jury.
Mr. Chairman, Eric Olson, I'm the Commonwealth Attorney in Stafford County. I'm speaking on behalf of VACA. We oppose this bill. It's not a big surprise. Mr. Chairman, I want to apologize for stepping out of the room. I was called out at a critical time. And I want to apologize to Senator Deeds for not being there at the committee meeting. We're on top of things all the time, as the senator knows, and we missed the posting of that meeting, and I apologize for not being there. Jury sentencing has a long history in the Commonwealth of Virginia, and it seems an extreme step to wipe that out without a study, without work on it. As I see the amendment today, now there will be bifurcated sentencings before a jury at the defendant's request, but victim impact testimony won't be permitted. That's stricken in line 524 through 526. Just a small measure of the implications of this dramatic change done so quickly and with so little input. I think
Mr.
it's.
Chair, Mr. Olson, the victim's testimony can still be admitted in a sentencing hearing with a court, with a judge.
Mr. Chairman and Senator Deeds, that's true, but if a defendant chooses a bifurcated sentencing in a violent offense, there would be no victim impact testimony for the body that's going to fix the sentence.
Mr.
And the jury
Chairman, if I may.
Senator Steve
And we mentioned when the substitute was adopted that more work needed to be done to make the substitute, to comply the substitute with the intent. And so we would reinstate all the previous provisions so that if a defendant requested a jury sentencing, that all the components that currently exist would exist at that time.
Mr. Chairman, I appreciate that comment. That certainly addresses the smaller issue that I just raised about changing how bifurcated sentencing would work if the change was made just so the defendant requests it. But the larger picture is the fact that we trust juries to fix sentence in capital cases, the most serious cases. And it seems to me that this bill is a statement that we don't trust juries to fix sentences in all other cases. And yet that has been our tradition, and it has worked well. And now, with this substitute, it's we don't trust juries to fix sentencing when the Commonwealth wants it, only when the defense wants it. The reason that trial by jury is such a fundamental right is this idea that in a community with your fellow citizens, you are entitled to have those fellow citizens decide your fate on issues of criminal justice. We embrace that. We embrace it in our Constitution. And it has worked with Virginia being one of 7 states that still continues to allow juries to fix the punishment as well. And VACA just does not understand why, when we trust juries to get it right in capital cases, when we trust juries from those fundamental issues, why this lack of trust in juries. And the last thing I'll say is, well, 2 things, if I may. Juries reflect the values of the community. We know with the recent changes in this body, in our ranks in Commonwealth Attorney's Office, that jurisdictions have spoken with their citizens on what they would like through their criminal justice system. That's reflected in verdicts of guilt or innocence with juries with your peers and in sentencing. And we trust juries to do that, and they get it right. And so I would urge the committee to take a good hard look at this. VACA opposes this. If you want VACA to sit down in a longer study on examining jury sentencing and whether it works, we're willing to do that. But to just throw out jury sentencing, except now with at the request of the defendant, it doesn't make any sense to VACA, and we would oppose.
Senator Morrissey.
A couple of questions. It's Mr. Olson.
Yes.
Mr. Olson, you mentioned several times in your argument about the fundamental right for the jury to do the sentencing. Can you tell the panel how many states allow the jury to do the sentencing as opposed to the judge?
I believe Virginia is one of 7 states that has still has jury sentencing in non-capital cases.
So 43 states have the judges do the sentencing?
Yes, the correlation would be 43
Follow-up
states.
question.
And the federal government.
And the federal government. All right. Follow-up question.
Yeah. Senator Morrissey.
Would you agree that the judges who in my bill would do the sentencing would have a lot more information at their disposal to impose a good or correct sentence, such as sentencing guidelines, the ability to listen to the victim, to be aware of what the mean sentence is, to be aware of what the normal sentence is in in their particular jurisdiction? Just a wealth of information that the jury doesn't have.
Mr. Chairman and Senator Morrissey, I would agree that a judge certainly has access and receives more information than a jury can in a bifurcated proceeding.
Follow-up question.
But if I may, that's why Virginia has the present scheme where a jury fixes the punishment, but the judge has the ultimate power over the punishment, except with respect to mandatory minimums.
Follow-up question.
Okay, Senator Morsi.
With regard to the last statement that you made, that the judge does have the ability to change the jury, would you agree that in less than 1/10 of 1% of the cases, the judge changes the verdict as imposed by the jury?
Mr. Chairman, Senator Morsi, that not in Stafford County, not my jurisdiction. It's much larger than that.
I'm sorry?
It's much larger than that.
Well, you're saying that the judge will alter the verdict of a jury?
Yes, sir. Yes, sir.
Okay. All right.
And if I may, Mr. Chairman, I've been prosecuting for 30 years. I was a defense attorney for 4 years before that. It didn't used to be the case when a judge would change a jury sentence, Mr. Morsi.
I'm sorry,
Senator
I was
Morsi.
listening to,
I've been prosecuting for 30 years. I did defense work for 4 years before that. There was a time where it was rare, if unheard of, that a judge would change a sentence. That is not the case now. That's not my experience in Stafford County. It's not the experience of some of my fellow prosecutors. So I would disagree with the basic concept that it's done in less than 1% of the case or just a small fraction.
Mr. Chairman.
Okay, Senator
Sir,
Searle.
Mr. Chairman, I just would note for Senator Morsi, I just pulled up the Virginia Sentencing Commission's report they did in 2018 where they looked at this. And in 2012, judge modified 21% of the time, but by 2016, it was down to 14.9%. It went down every year. And I don't have any data after 2016, but it looks to me like it's either 1 in 10 or 1 in 5. It was happening at least back then.
Okay. All right. Where are we on this case, this bill? There's a substitute that's been before the body. Move to report.
Second.
It's been moved and seconded to report. All in favor, as amended, all in favor to report the substitute, vote aye. All opposed, vote no.
Ayes 10, noes 5.
10 to 5, the bill is reported, the substitute's reported. Okay? Now we move on, finish with the subcommittees. Senator Donovan is here. Okay, well, to be back. All right, so we move on now to bills with fiscal impact. Senator Cosgrove, is that the one we passed by, 195? No. Okay, where are we? Where do we go next? The bills under Block 2, which have a fiscal impact, they need to be referred to finance today. Okay, here she is. Senator Donovan. Okie doke. We have Senate Bill 585.
Thank you, Mr. Chairman. Senate Bill 585 has already had a tortured process that it's been through. But I think we have a good bill to present to you today as a result of that. This is a bill that came out of a study in the Joint Commission on Health Care. And it was looking at supported decision-making with the best intent to set up a situation that would be beneficial to many in the Commonwealth. However, I think that we may have put the cart before the horse, because a lot of the stakeholders that would be involved in actually implementing that process had a lot of problems with the bill. So the substitute that you see before you now, which I hope is being distributed, actually strikes the portion of the bill that had anything to do with supported decision-making. Instead, you'll see a new enactment clause on the back starting on line 206 that will direct the Department of Behavioral Health to convene a work group of those said stakeholders that will be able to implement this in a more practical manner and come back to us next year so we can act on it at that time. What remains are some changes in guardianship that I believe have good consensus on them. Several amendments have been made here. I know that Finance has asked for this bill. I don't think in its current form it needs to go to Finance, but it'll be yet another one of my bills that goes to Finance that doesn't need to be there. But basically, the fiscal impact that related to DBHDS, they believe they can cover. The fiscal impact that related to DOE has been removed. We've changed the language regarding DOE to accommodate that, but the bill is as it is before you, Mr. Chairman.
Okay. Any questions? Okay. You have a substitute in front of us?
Yes, sir.
It's been moved and seconded to adopt the substitute. All in favor say aye. Aye. All opposed, no. Motion carries. Is there any question? Do you have anybody speak for the bill?
If you would like, Mr. Chairman, but if you like the bill, you can just move forward. We have Joint Commission on Healthcare to speak to it if you'd like to.
Yeah, go ahead.
I'd like to know how this bill relates to Senate Bill 352 from Senator Lucas.
That would be outside of my scope. I don't know.
Similar, or do they overlap, or they in conflict?
I believe and perhaps Joint Commission on Healthcare can speak to that, but there were several aspects of the study that was done by the Joint Commission on Healthcare, and I know Senator Lucas wanted to carry one aspect of that, and I was given the rest.
Is somebody from the Joint Commission to explain that? Yeah, come on up.
Hi, I'm Stephen Weiss. I'm a staff person with the Joint Commission on Healthcare. And are you asking about Senator Lucas's bill?
I was just asking how the two bills related. If they were in conflict with one another.
Oh.
Yeah, Senator Kristen.
Mr. Chairman, Senator Lucas's bill just included some language about supported decision-making, which Senator Donovan's bill has now taken out, so the bills are no longer in conflict.
Okay, all right, so we're in good shape. Is there a motion? Yes, Senator Stewart, been moved and
Mr. Chairman.
seconded to report and re-refer to finance. Yes, Kristen?
The substitute has taken out all of the language that would have required the fiscal impact, so I do not believe it needs to go to finance anymore.
Good enough. Okay, this motion's been made to report the substitute. All in favor of the motion, vote aye. All opposed, no. Okay. All right. 15-0. Congratulations.
Thank you,
The
Mr.
bill
Chairman, members of the
passes.
committee.
Now we move on to, let's see, Senator Dees, you want to go into your
Senate Bill
326?
326, and this is a jury sentencing bill, so I'm not sure if it's still in order, but what this bill says is basically it gives the jury the same kind of, gives them access to more information, gives them more choices if once the defendant is found guilty. 326 gives the jury the ability to propose a suspended sentence or probation. If the jury recommends suspension of the sentence imposed, or that sentence of multiple offenses be served concurrently, they can do that. But again, I'm not sure.
Mr. Chairman,
Senator Searle.
speaking of the bill, I would just say that I think we need to pass this along without knowing what's going to happen with Senator Morrissey's bill. I think the safe thing to do is to pass both and see what happens.
Okay, well, Charles just handed me an amendment. Maybe you can explain that.
Mr. Chairman, if we were talking about doing this at the beginning of the session, maybe understand that argument, but we're going to have now two disparate concepts going out. The last one signed by the governor is law. We need to make a decision. I mean, I certainly was not in favor of the previous bill, but that was the decision of the committee. You can't do both ways. You got to call. When we were in P&E yesterday, we certainly had different views on how that, we don't know what will happen to them, but you have to make a decision.
Mr. Chairman.
Yeah, Senator Searle.
Thank you. I guess my query to Senator McDougal would be whether he voted for my texting while driving bill and Senator Kiggin's texting while driving bill, which both passed and had very disparate points of view on hands-free.
Mr. Chairman, I think I informed Senator Surville that I think both of those bills reduced the penalties for texting while driving, so they were not the best policy decisions if you want to protect the citizens of the Commonwealth.
Mr. Chairman, what I would, I basically agree with Senator McDougal that the committee should only adopt one policy. But if we went forward with this, and the other bill happened to make it through both sides, I would ask that, and this bill does too, I would either ask the governor not to sign this bill, or I would strike it somewhere in the process.
All right. Okay. All right. Yeah, Senator Morsi.
There's the opportunity and certainly perhaps maybe probability that as this moves out of committee and before the full House, that one of the patrons may move to do just that, to kill it. But I think we need to vote on this bill right now, if we, up or down, depending on the merits of this bill.
Well, Charles had an amendment to this bill.
Mr. Chair, there is a line amendment to the bill. It is on line 38. It's that last sentence. And the amendment would strike that last sentence, which recommends placing on probation, full or partial restitution, community service. The amendment just strikes that last sentence, so the jury would not be recommending that part of the bill.
All right. Okay.
And I'll move that amendment.
All right, it's moved and seconded that the amendment be adopted. All in favor say aye. Aye. All opposed, no. All right,
The
pass
bill
vote.
as amended simply gives the jury the same kind of options with respect to the sentence that the judge has, to suspend or run concurrent. And I would move that the bill as amended be reported.
Okay. It's been
And re-referred to
moved-
finance.
Moved and seconded that the bill be reported and re-referred with amendment, that the substitute be reported and re-referred to finance. Any, moved and seconded that? Okay. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 10, those 3.
Okay, ayes 10, noes 3, the motion carries. Okay, moving on down the list here in chronological order. I have Senate Bill 511, the governor's bill with regard to the petition for writ of actual innocence. Is somebody from the governor's office here? Well, we haven't gotten to that yet. Oh, it is? Okay. All right, well, okay, this Senate Bill 449, Senator Turble?
Yeah.
Do you want to bring that up?
Sure.
It abolishes the death penalty, right?
Let me do it from here.
Okay, very quickly.
You want me to do it from here?
Yeah, go ahead. We're doing this because some people have to leave.
Okay.
Just explain it.
Mr. Chairman, Senate Bill 449 would repeal Virginia's death penalty and would also state that the 2 remaining people on death row be converted to a life in prison without possibility of parole. From my perspective, I have 6 reasons I think we need to do this. I'm sure there's some others. Number 1, the risk that we could execute the innocent. We already know that there's at least 110 people in the United States of America that were executed who were innocent, and probably some people in Virginia. Earl Washington, we know, almost suffered that fate. Number 2, I think it's impossible to receive a fair trial anymore when it comes to the death penalty. There was a Gallup poll that came out about a month ago, which showed that over 60% of Americans now believe that life in prison is a more appropriate sentence than a death penalty. And I don't know how you can get a fair jury when 60% of the public doesn't think it should be an option. So, when you're supposed to get a trial jury by your peers when 60% doesn't agree with the sentencing option, I don't know how we can give people a jury their peers anymore in this country. Number 3, the United States is an outlier. Right now, we stand with China, Iran, Saudi Arabia, Vietnam, and Iraq, and in Egypt in terms of how many people we're executing. Number 4, there's massive equity issues. In terms of poverty, I think that people who are non-white tend to get punished under the death penalty more often than they should, or disparately, I should say. People with diminished intelligence, brain injuries, mentally ill people, I think, tend to get have these cases brought against them. I would note for the committee, this is incredibly expensive. Abolishing the Capitol Defender Service would save taxpayers $3.9 million per year. That's 1/3 of what we spend on court-appointed lawyers in the state, and I think that money would be better spent doing something else. And lastly, we can't get the drugs to do it anymore because the rest of the world has basically said this is a immoral practice, and so it's becoming increasingly impractical to do this. And I'm sorry, the 7th thing I would say is we heard from a victim about a week ago, Rachel Sutphin, who pointed out that this doesn't always provide the solace to victims that I think victims might think that it does, and I just think this is outdated. I would move to report my bill.
Okay. It's been moved and seconded. Anybody want to speak one way or the other? Huh? Yeah, well, is there a motion to adopt a substitute? All in favor of the motion to adopt a substitute, say aye. Aye, all opposed, no. Okay, we've got the substitute. Go ahead.
Mr. Chairman, Wayne Huggins, State Police Association, and we very respectfully but very strongly oppose this bill. You will remember that about a year ago, almost exactly a year ago, a number of state police widows stood here before you. The case that precipitated that, and I'd like to address specifically one of Mr. Servell's, Senator Servell's points. If we were convinced that those who are convicted of capital murder of a police officer were going to get life without parole, then our opposition might not be as strong. However, in the case of Special Agent Mike Walters, who was shot and murdered less than a mile from where we were sitting, his killer got 36 years. 36 years. That same person, within the last 2 months, has been charged with assaulting with a shank and stabbing a number of times a fellow inmate in the correctional center. During this session, I have sat in courts for hours, as you all know, and I've heard discussions on both the House side and the Senate side about reinstating parole. Now, that may or may not happen this year, but I've been around long enough to know when something starts getting talked about, eventually it's going to get passed. So this combination of events of having a man that shoots a state police officer in the head with an extensive criminal record and gets 36 years, and actually the judge apologized to that person for his upbringing. To me, that sends a message to law enforcement throughout the country, and particularly in the Commonwealth, that your life that you gave is no more valued than that. And to me, it just sends a very chilling message to law enforcement when we talk about eliminating capital punishment for a conviction of killing a police officer. And for those reasons, we strongly oppose this. But again, very respectfully to Senator Servell.
Thank you very much. It seems to me this is an issue that's going to take a while to go through. We got limited time. Is there a motion?
I'll make a substitute motion. We got a big agenda, and I mean, there's no secret what my views are. I move that the bill be carried over for the year.
I second.
Any discussion?
Can I speak to the motion?
Yeah, but go ahead.
Thank you, Mr. Chair. And I know there's a lot of people with very strong opinions on this issue. Let me make a couple points and events that were transformative in my life. In September 11, 2001, a plane was hijacked and it was flown into the Pentagon. It crashed and killed 340 people. Multiple of those people lived in Fairfax City, my hometown. And it had a huge impact. I remember seeing the children and the widows here crying when they were recognized by the state. The people that committed that crime and killed those people had a level of hatred in their heart that people in this room cannot understand. They can't understand. And we passed a law saying that if you committed an act of terrorism, this is in the 2002 session, that you would be death eligible. And I voted for it. Not but 7, 8 months later, we had a pair of men that went through the DC area shooting people, innocent people, white people, black people, Indian people, Korean people, in the head, in the back, without any warning, premeditated acts of homicide. Those people were eventually captured and they were put on trial in front of a Virginia jury. The jury reached two different conclusions. For the man who masterminded it, they reached the conclusion of death. For the younger man, who I believe was 18, they gave him life in prison. I could have lived with it, either one, but the bottom line was there are certain acts of violence which can only be recognized in a certain way. And life in prison is not that recognition. So I may be in the minority in this building, but I very humbly will second this motion.
Okay. Any discussion?
Senator Norman.
Mr. Chairman, I missed part of the discussion, but I did catch the tail end of the comments by Senator Peterson, and I don't have the emotional or experience that he does, but when I was first elected to the General Assembly, I had tried more capital murder cases than any attorney in Virginia. And sometimes when you're involved in this, you have to segregate your professional opinions from your personal opinions. And as a result of that experience, and I no longer engage in that type of criminal defense work, But I did come to the conclusion that there were some individuals whose behavior was so habitually inculcated in them and so aberrant that they needed to ultimately pay that ultimate price for that which they did. And I understand moral, religious resistance to that, but I just very candidly came away from those experiences believing that there are those whose behavior is such that it warrants the ultimate punishment.
Okay. Any further discussion? We've got other things to do, so.
I understand.
Yeah, go ahead, Senator Morrissey.
Mr. Chairman, we are not going to resolve this if we have two sides, one saying that some behavior is so abhorrent, so vicious, so vile that it warrants the death penalty. Let me tell you, I agree with that. Period, paragraph, full stop. That's not what Senator Servo was saying. He was talking about that body of individuals who were sentenced to death. And let's be clear what that means. They were tried by a jury, they were sentenced to a death. The judge reviewed it. It probably went through 3 appellate processes, both in the state and the federal habeas level, and sentenced to death. The statistics show that 110 men have been removed from death row during the last, since death penalty was reinstated, because they were innocent. Let me just restate that. 110 people were on death row, been convicted and sentenced to die when the prosecutor came forward and said, we agree, we got the wrong individual. In Virginia, there is overwhelming evidence that 6 individuals were wrongfully convicted, and 2 of them, Roger Coleman and Joseph Odell, were executed. And 18 people in Virginia have been exonerated after having been wrongfully convicted. One exoneree, Earl Washington, was proven innocent. He had an IQ of 69, and after extensive questioning in 1982, he admitted to doing it. However, later on, DNA evidence showed that he was innocent, and the prosecutor moved to release him. And 18 years later, after being in prison, the governor granted him not a pardon, not a partial pardon, an absolute pardon. And Senator Servo talked about the disparity in who requests it. It is desperate from one jurisdiction to another. So that's the problem. Not that some people commit such vile offenses that doesn't warrant death. I agree. It's that we get it wrong. And let me just say this. We get it wrong, Mr. Chairman, on evidence that there is evidence that you can measure. There's empirical evidence that you can measure with DNA. You know what you can't measure? You can't measure a false identification. So that's why, and I think I might be the only person in this panel that has tried somebody and sent them to death row and defended somebody and kept them off death row. So I have some experience at it, and it is just because we get it wrong, not once or twice, but over 110 times. We got it wrong. That's why I don't think that this should be put off a single day. And I think that, and I oppose the motion to carry it over to next year.
Mr. Chairman.
Senator Stanley.
Thank you, Mr. Chairman. Mr. Chairman, as you know, and I've stated this on the Senate floor, both in my professional career and I've seen the government get it wrong, and that's probably my biggest worry. And I have all the compassion in the world for the superintendent and what those families go through when someone loses their life in the line of duty. And I know the anger and how it feels. And quite frankly, I've described this to you, and I say this in all honesty. My faith and the logic that I apply in my job, the way I was raised, gets me to the position where I support the abolition of the death penalty. However, the motion on the floor is to carry it over for a year with us really taking a serious look at this. I am comfortable to know that most of the juries right now in capital cases are not sentencing to death, that those numbers are shrinking. I think this issue is so important so that all of Virginia can be involved in its discussion, so we can have an honest and intellectual discussion of this. My vote when this bill does come up will always be for abolition of the death penalty. But I think that the smarter motion at this time, because we owe it to the Commonwealth of Virginia, instead of just rushing it through on some 5-minute hearing
and not having time to have that discussion, that philosophical discussion, we do a disservice to the state. So I support what Senator Serville's trying to do, but I think that we need to be deliberate and we need to be conscious about what we're doing, and that at the end, we have made a decision that is right and just and for all of Virginia. Thank you, Mr. Chairman.
Okay, the motion is on the floor.
Mr. Chairman.
Is to pass it by.
Can I speak to the motion to do something to my bill?
Senator Serval.
Thank you. Mr. Chairman, I oppose this motion. And for a couple reasons. First of all, nobody here means any disrespect to law enforcement. And I appreciate law enforcement frequently ends up in very difficult situations and where this has to come into play. But I don't think that whether the death penalty exists or not it enters into anybody's mind if they decide to shoot a police officer. I just think that that's not part of the equation for them. I don't think it deters anybody. But I understand the feeling that there needs to be that sanction available. But I would note that we haven't had a capital murder, we haven't had a death penalty verdict in this Commonwealth for 8 years. 2 years ago in Prince William County, just outside my district, a gentleman murdered his wife with an AK-47. And when 3 police officers showed up at the house after she had called 911 because of the situation, he opened fire on them before they could open the door. He shot 3 police officers with that AK-47, killed a woman on her first day on the job on the police force. That man, Paul Ebert, took him to trial on capital murder, and the jury didn't give him a death sentence. The jury was hung up. Our society, Virginians, are not doing this anymore. Gallup came out with a poll last year that said 60% of the public opposes this now. We're spending $5 million a year of money that could be spent defending on court-appointed cases on something that we're just, people aren't doing it. And if we push this off a year, we're going to have more of these cases continue to be litigated to no conclusion, which isn't going to buy finality for anybody, the victims or everybody else involved in the situation. Our system is spinning its wheels on something that's only done in the third world, right? We stand with China, Egypt, Iran, Iraq. I don't want my state to be in that list. And that's who we're standing with right now because we want to keep this on the books. It's time to end this practice. It's way overdue. And I think by pushing it a year, we're not going to change. I think everybody in this committee knows how they want to vote. And I don't think another year is going to change how this committee votes. I also don't think it's going to change how probably anybody in the body votes. And I think we need to get this over with.
Okay, the motion is to pass it by and carry it over for the year. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 9, noes 5.
9 to 5, 9 to 5 and 1. The motion passes to carry it over for the year. This is a big issue, and we'll be continuing this discussion next year. All right, Senate Bill 511.
Mr. Chairman, would it be appropriate now, since we just had that discussion, to take up my SB 802?
Can we carry that? Because we need some bills to get out.
So whatever.
We'll come back to it. All right, Senate Bill 511, which is the petition for writ of actual innocence, that the governor's bill, the deputy secretary for public safety and homeland security. Thanks for being here.
Good evening, Mr. Chair, members of the committee. I'm happy to go over the bill. What Senate Bill 511 does is it modifies the requirements for writs of actual innocence relating to biological and non-biological. Under the biological section, it requires a certain type of a plea and certain type of convictions, and it gets rid of that restriction. It also changes the standard of proof for the allegations that are in the petition from clear and convincing to preponderance of the evidence. For the non-biological section, it also changes the fact that it requires a not guilty plea, and also gets rid of the limitation that only one petition could be filed. There's also added provisions regarding when an evidence was not, a test for an evidence was not available at the time. And then lastly, it also changes the clear and convincing standard to preponderance of the evidence.
Okay. Any questions? Any questions? The bill is in good shape, I think. Yeah, Steve?
Mr. Chairman, since the bill is before us, let me point out one thing that the bill does not do. It's a good bill. I don't mean any harm to it, but this is a very important writ and a very important form of relief. It exists so that somebody who is actually and demonstrably innocent can come to court and try and gain their exoneration. These statutes were created, written and drafted and enacted back in the year 2000 and 2001 during that time, when Virginia had just discovered that we had decades of people who had been convicted who could now be exonerated by DNA. But because convictions are final 21 days after they're entered, people who were demonstrably innocent had to stay in prison. And so these statutes, this mechanism was created, and trust me, it was a compromise between those folks in the Commonwealth who said finality of a conviction is the most important thing, and more important than actual innocence. So a compromise was created. And part of that compromise was that you can ask for, if you're actually innocent, but you're serving a life sentence in prison, if you think that there is DNA evidence that will prove that you are innocent and collaterally prove who actually did commit the crime, if you believe that evidence exists, then you can ask for scientific testing. And that was very important. But you can only ask for that scientific testing if the evidence was not known or available to you or your attorney at the time of your conviction. If you get the DNA proof that you're actually innocent, then you can go to court and ask to be exonerated, but again, only if that evidence wasn't available at the time that you were convicted. And so even if you're demonstrably innocent and you're serving a 50 or 60-year sentence, if your attorney failed to find the DNA evidence and get it tested when at the time of your trial, the fact that you're innocent is meaningless. And so if we wanted to correct this, oh, and I should also say that if you were convicted after 1996 and the evidence could have been tested at DFS, you also get no relief, even if you are demonstrably innocent. And so because these important statutes are before the committee, if the committee wanted to remove the prohibition for someone who can prove that they are innocent through scientific evidence, through DNA, so even if the evidence existed at the time, this would be the opportunity to do so.
Okay, good. Yes, Senator Morrissey?
Mr. Chairman, I appreciate the comments of the staff attorney. I want to also say this. If you're looking at the possibility of being executed versus taking a plea and avoiding execution, let me rest assure you there are people that do just that. The evidence shows that they are innocent, but there is strong evidence that they are, if they went to a jury, they could be convicted and sentenced to die. They will enter a plea. So I very much like that provision that irrespective of the plea that was entered, if there was biological or non-biological evidence. And the other thing, and I think it warrants underscoring, is the following. I don't know if everybody paying careful attention to what Mr. Benjamin said. There are cases where if the defense attorney, whether through not being diligent, inadvertence, whatever, did not discover evidence that was available at the time and proves conclusively that he's innocent, tough luck. And if anybody thinks that that's fair, then we have two different universes. So I support this bill, but I also, and I would ask staff, I have a similar bill, 823, and it's a couple of different provisions to it. I don't know if it should be rolled in, Senator Edwards, or if mine should be considered after
Let's do
SB
this.
511.
Let's do this bill, because I think this
Okay.
bill's in pretty good shape. But
And Mr. Chairman, if any member of the committee wanted a line amendment that would achieve what I have suggested, I can provide that now.
Okay. Any further discussion on this bill?
Mr. Chairman.
Yeah, Senator Obenchain.
Well, a couple of things. Number one, and I apologize, I stepped out. I am very interested in hearing from the Commonwealth's attorneys. And as I stepped out, there's a gentleman over here who's been waiting all day for this bill. And I would ask that he be allowed to testify.
Okay, who is Commonwealth's attorneys want to say something first?
Good evening again, Mr. Chairman, Nathan Green, Commonwealth's Attorney for the City of Williamsburg and James City County. Your Honor, the Virginia Association of Commonwealth Attorneys took a very hard, good look at these bills, both Senator Morrissey's as well as this one. We are absolutely in agreement with the concept. There should be no procedural bars when someone is innocent. We are in favor of removing the procedural bars. However, with the bill as written, we did struggle with the fact that we were trying to shoehorn in some scientific language in the non-scientific part of the statute. We had some fixes that we thought would both clear the procedural bars, but make it a little bit more streamlined in using the biological statute as opposed to shoehorning it in other places. It also would make use of 327.1, which is actually the provision that allows for the testing to be done. At this time, if it's not biological, you can't get the testing done. So there has to be a mechanism for there to actually be testing in order for there to be some conclusion about the innocence of the individual. So again, we support the concept. We support removing procedural bars to actual innocence. We would like the opportunity to work and make these bills a better fix for what we do see as a problem.
Okay, maybe in the other side, the other house can be worked on, or before we go to the floor, or something
Mr.
like
Chairman,
that. Today's the last day to get it out of
Chairman,
this committee.
I
Yeah, Senator McDougal?
I cannot imagine something more important than the bills that we're discussing. Why are we not fixing them here if they're fixes? I mean,
Because
this
we
is
got
this is what we
get them out of
should be
committee
doing.
to go to finance if that's necessary. There's another gentleman here who would like to speak.
Well,
You know,
Mr.
come
Chairman,
on up.
if it's not ready, it's not ready, and it should go no further.
Your name?
My name is Scott Campbell. I'm the nephew of Anna Jean Anderson. She was a victim of a crime on September the 4th, 1996. A lot of what y'all said today has been really relevant to a lot of things I've been thinking about, because the last 6 months of my life has been pure hell. And the last 6 weeks, it hasn't been getting any better. Because the offender that killed her is publishing nice little how-to manuals of how to get your security designation downgraded through the DOC system,
You know, this is
replete with pictures.
You understand this is a bill of somebody.
Yeah, I
claims to be
do. And
innocent.
his conviction hinged on DNA evidence that he was the one that raped my aunt while he was murdering her and not the other defendant in the trial. His guilty verdict by the jury was probably decided by that DNA evidence, which was destroyed in 2007 by a court order. But there was also fingerprint evidence in that case that led to a great deal of conjecture by the defense attorney at the time. This bill would basically give this offender unlimited opportunities to file writs to continue to torture and terrorize our family from behind bars. So I vociferously oppose it. And I would also submit to you that everything that Senator McClellan said is probably true, but in this particular case, the inverse could be true. Right. So to be careful that something that you're designing to free someone who is totally innocent doesn't get deployed as a tool against a victim's family in a case where the scientific evidence is actually kind of the opposite of what you described.
Okay.
So this bill will have a significantly negative impact on my family and myself, and I understand what it's asking for. And I don't know who it's drafted to benefit, but I do know who is going to use it to continue to terrorize me and my 79-year-old mother and the rest of our family.
Okay.
So
Thank you.
anyone who would like, I'd ask for the clerk to make copies of the judge's sentencing summary for my aunt's case and give them to each member of the committee. I tried to get them around to everybody yesterday, but I got fluffed off by a whole lot of people. So
Okay, thank
I'd
you.
like to
We'll-
just
we'll be
hand them
glad-
to whoever
we're
will
glad to-
take them, if
glad
that's
to
all
receive
right.
it.
I'll need however
We'll
many
be glad to
copies.
receive it.
Mr.
Okay.
Chair?
Yeah,
Thanks.
Senator McClellan?
Yeah, so just to clarify, and thank you for coming, I'm Senator McClellan, he is Mr. Bishop.
Oh, well, the names are swapped.
Okay,
Or, well, I guess you just don't have one.
right.
Sorry.
Okay.
I'm just a lawyer.
I apologize.
It's okay.
Deputy anybody else like to speak for or against the bill? Deputy Secretary, do you
I
have
only
anything
have one
else,
copy.
thing to wrap it up?
Someone
In
said that
response
you
to
could
some of the
make
other
copies for each of the members for me.
issues that have been raised? No, okay. All right, is there a
Thank you.
motion?
Second.
It's been moved and seconded to report and re-refer Senate Bill 511 to Finance. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 10, noes 4.
Ayes 10, noes 4, the motion carries. Next bill, I have a bill on driver's licenses. Senator Stanley's, I guess.
Senator Edwards?
Yes.
Again, my bill is very, very similar. Do you still want to delay it?
Yeah,
Okay.
if you don't mind, okay. This bill, Senate Bill 512, it says to be incorporated in Senate Bill 513. Is that, is it, but I think they're a little bit different. Is there a substitute on this, Charles? No? So do both of them or what?
Mr. Chair, there's no substitute on it, but the bills are very similar and accomplish the same thing. There is an amendment, though, to 513, which is 3 amendments that are largely technical.
Okay, well,
And
I move to roll Senate Bill 512 into 513. Is there a second? Second. All in favor of the motion, say aye. Aye. All opposed, no. Okay.
Mr. Chair, the
Bills-
way they've done those in other committees, I think, was a strike. When one patron has 2 bills, they don't roll them, they strike one, and isn't that the way you explained it to me before?
Well, we can do it. We can do it this way. Yeah,
Okay.
incorporate, yeah. Yeah, okay. All in favor of the motion, say, we got to vote. All in favor, vote aye. All opposed.
Just incorporating
Yeah, just
512 into 513.
Incorporate, okay.
Okay.
Ayes 9, noes 4.
Okay, Senate Bill 513. Come, step right up and explain it.
Mr. Chairman, members of the committee, Nikki Zmosny, Deputy Secretary of Public Safety and Homeland Security. Senate Bill 513 eliminates suspension of driver's licenses for mandatory suspensions for drug offenses. It does not remove a judge's discretion to suspend a driver's license. It just gets rid of the mandatory provisions in the code. There are currently more than 126,000 people in Virginia whose licenses are suspended for non-driving related offenses. This would allow them to get their driver's licenses back and support their families, maintain legitimate employment.
Okay.
And the
How about the-
administration.
What about
Thank
the
you, Senator
failure
Edwards,
to
for
pay
carrying the
jail
bill.
fines
What we've already done.
and jail fees and driving without paying for fuel? Is that?
Mr. Chair, I'd ask if this is different from the Senator Stanley's bill that we've already passed.
Yes, this bill is different. Senator Stanley's bill deals with inability to pay fines and costs. This bill has to do with non-driving related offenses, so drug crimes and
Okay.
the other crimes that Senator Edwards mentioned.
Okay, all right. Okay. Any questions?
What are the other offenses?
It is
Non-payment
Counsel?
of certain fees owed to local correctional facilities and regional jails and for shoplifting motor fuel.
Right.
All right? Okay. All right. Non-moving violations.
So stealing motor fuel?
Yes, Mr. Chair, there is a penalty for stealing motor fuel that can get your license suspended, and this bill would remove that provision.
Mr. Chairman, I mean, didn't we adopt a bill like this last year? Or didn't one pass out of the Senate like this last year? Or maybe I'm mistaken.
Mr. Chairman, to answer Senator Obenchain's question, we've had this bill from Senator Edwards before, but it's always been either not passed the committee or rolled into Senator Stanley's bill in some form. So it has been considered, but it's never actually passed the body.
Maybe I was thinking of Senator Evans' bill.
Does the Secretary of Public
Seriously.
Safety and Homeland Security, who happens to be here, I believe, would like to say anything?
I'm sure the deputy secretary.
Your deputy's done a great job. You may not want to.
But the motor fuels, it's never been prosecuted. There's never been a case for the motor fuel, so that's why we just kind of cleaned it up.
Okay.
Never been used, so we thought we'd just eliminate it with this bill that's relevant to sort of is a moving violation, but it's never been prosecuted, so.
Okay, all right. Is there any discussion? All
Move
these
to
are
report and
motion.
refer to finance.
Oh, we have a line amendment.
Yeah,
Okay.
Mr. Chairman, as I said, there were 3 line amendments. They're all technical in nature, essentially striking where there is mention of suspension of license and some enactment, some catchphrases, and that's basically what the three line amendments do.
Is there a motion to adopt the line amendments?
So moved.
Second. All in favor say aye. Aye. All opposed, no. Motion carries. There's a motion on the bill as amended.
Mr. Chairman,
Yeah.
so did I hear y'all say correctly that the court still is permissive to suspend the license, or is that permissive language gone too?
That permissive language is gone.
Okay. Okay. Is there a motion?
So, Mr. Chairman.
Yeah, Senator McDougal.
So, under the marijuana statute, what we did was said if you're driving and you're possessing marijuana, then there was still some ability to suspend. Now you can be using heroin or cocaine or prescription medication while you're driving, and the court will have no ability to suspend your license. Is that accurate?
Charles would.
Can you repeat your question?
Mr. Chairman, last year under I think it was Senator Evans' bill that Senator Ebenstein was referencing, possession of marijuana, if you possess it while you're driving, court still can suspend your license. Under this change, if you're convicted of possession of heroin, cocaine, prescription pills, whatever, while you're driving, the court will have no authority to be able to suspend your license. Is that accurate?
I believe that is accurate.
Okay.
Does that include while you're under the influence, driving while under the influence of those drugs?
Mr. Chairman, no, because that is a moving violation. So that for DUI, it would not be the suspension would still be intact. It would be if you are in possession of heroin, and that is what you're convicted of, that would not allow the license suspension.
Okay. All right. Everyone understand? All right. Is there a motion to
Report and refer to finance.
motion to report the substitute and re-refer to finance? All in favor vote aye. All opposed, no.
Ayes 9, noes 5.
Ayes 9, noes 5, motion carries. Okay, the next bill is, I guess, Senator Norman has 607. See here? All right, Senator Boysko, 660. Did we do that? We did that. Okay.
607 is identical to 195. You got some people sitting out there, you got Vola and
Okay.
Lewis.
All right, let's see, who do we have here? Well, I want to get the bills referring to finance first. Senator McClellan, Bill 723. Senator McClellan.
Yes. Senate's Bill 723 is a bill similar to one I brought last year to create more transparency in the pretrial services by requiring the Department of Criminal Justice Services to collect data related to bail determinations and create a uniform mechanism for criminal justice agencies to submit such data. Under the bill, the data will be reported annually to the governor and the General Assembly and published on the department's website. what this bill is trying to do is collect data so that we can try to figure out why it is that on any given night, 46% of the 28,000 people who are in jail but have not been convicted of any crime. We have no real data that would show us reasons for bail denial, bail conditions, the bond amount required, the cost of the jail stay, what charges they're being held for, whether they have homeless status, their race, age, or gender. But what we do know is that most of the people who are in jail without having been convicted of a crime are people who are of color mostly and poor, and that while they are incarcerated or in jail pre-trial, not having been convicted of any crime, they're very likely to lose their job or income. They will face housing insecurity, separation from their family, et cetera. So that really is the purpose of the bill, so we can get a better sense of who's being held pre-trial and who's not, and why.
Mr. Chairman?
And I do have a line amendment.
Okay, yeah, a line amendment, this is a line amendment.
Mr. Chair, on line 18, after the word "of," strike pretrial.
Okay, is there a second? All in favor of the motion to adopt the line amendment, say aye. Aye. All opposed, no. Motion carries. Okay, Senator Obenchain?
Is the Crime Commission here?
Crime Commission. Anybody from the Crime Commission? Okay.
I think I can anticipate your question. While this bill was referred to the Crime Commission last year, when they studied pretrial services, they did not study any of the data that was requested in the bill or any of the issues specifically dealt with in the bill.
Mr.
Okay,
Chairman?
Senator Obenchain?
My question, though, is that the Crime Commission has spent 2 years and a lot of resources across agencies on a massive data project, and I just want to make sure that this is not inconsistent with or with that work.
My understanding is it is not.
Okay.
I don't see anyone from the Crime Commission here.
Nobody from the Crime Commission.
I think
Senator
they are
Obenchain?
in the House, and that's one of the challenges of meeting at night.
Okay.
Mr. Chairman?
Yeah, Senator McDougal.
Mr. Chairman, I think Senator McClellan just talked about the 19.2.134.1. What is the 19.2.119.1, that purpose section? We've not talked about that. I think that's where the amendment came, but that seems substantially different from the remainder.
I'm sorry, can you repeat?
The
Senator
reason,
McDougal, go ahead.
Mr. Chairman, the data collection part, I
Oh.
think we all understand, and logic to collecting data to make better decisions. Tell me about altering the purpose section. Mr. Chairman, you know from Code Commission, we've kind of tried to eliminate those statements out of the code on many things, so I'm trying to understand that section.
Okay, so you mean
Senator
lines
McClellan.
14 through 18?
Yes.
Okay. I guess if it is the will of the committee not to state the purpose, that's fine, but I think we just felt we should state the purpose for which the data is being collected.
Well, the Code Commission's a little bit both ways sometimes on that issue.
Mr. Chairman, but I think you and I both carried bills that struck out statement of intents this year from other sections, so.
That's true.
Mr. Chair, I don't know that that section does any, and that's why I asked the question. I didn't make a motion.
We
I
don't
was asking.
gratuitously put purposes in bills, but occasionally when it's necessary to help explain it. But anyway, would somebody like to speak? Yeah, go ahead.
Yes, thank you very much, Senators. My name is Mark Bernard. I'm from the Office of the Executive Secretary with the Supreme Court of Virginia. And the data collection bit is what it is, and we had the fiscal impact for that. I think the Senators are well aware of that. The concern that was raised by the court when this bill was being reviewed, and for example, I'll skip down to line 42, and something stating the reason for a denial of bail. if a court not of record conducting a bond hearing is now required to record a reason for a denial of bail. The court was concerned that we're shifting courts not of record to being more courts of record. And that was a concern that the court wanted to make sure that the senators were well aware of prior to voting on this bill.
Okay.
Well,
Yeah, Senator
I mean,
Deeds.
what does the court think about this purpose language? And what I'm thinking about is, you've got a number of offenses for which, for which a presumption exists against pretrial release. And when you've got language that this article should be interpreted and construed not to give effect to a general, so as to give effect to a general presumption in favor of release, I mean, I would probably favor that. But I think that creates a conflict in the law, doesn't it?
But respectfully, Senator, the court on that particular section, we took no position, being primarily the policy decision of what the General Assembly wanted to put in this particular bill. We were concerned more with the aspect of shifting a court not of record to being one of record.
Mr. Chair, and that is not the intent of this bill, and I think I saw Adiola from Legal Aid Justice Center, who had some conversations with me on this bill on that very point, who I think can speak to that point.
Mr. Chair.
Yes.
Senators. Hi, Adiola Gunkede, Legal Aid Justice Center.
Okay.
I'm a legal director of one of the programs there. We did work with the Senator's office on this bill. I think to speak to the purpose section, that language was included simply to give force and effect to language that is already in the code, but because of its placement is buried and does not get read in favor
Chair.
of a presumption of release.
Okay.
So it's not changing.
Where's the
anything that
language in the
exists.
code, though?
Senator Deeds.
So it is in section 19.2-120.
Okay. All right. Anything else?
As to the issue of courts of record versus courts not of record, I think, that is determined by statute. That's already dictated in the code by statute. So the question of whether or not recording or collecting information that is happening during the court process, whether that would turn a court not of record into a court of record, I think is inapposite to this discussion, given that courts of record versus courts not of record are determined solely by statute. And I think, perhaps OES is looking at a question of administrative burdens and recasting it as a legal question. But given that courts of record versus not of record is wholly determined by statute, I don't think this bill would run afoul of that. We also have here, in support of the bill, a representative, the president of the Virginia Community Criminal Justice Association, Gary Hughes, and I'll let him speak.
And before he comes up, can I just add another point? This is also sort of aggregate anonymous data. So when you are collecting this data, it's not going to say, Steve Benjamin was denied bail because da-da-da-da. It's going to collect the data in the aggregate anonymously per person. So that's another reason why this is not turning a court that is not a court of record into one that is.
Yes, and in fact, proceedings are already by statute, in the general district court, proceedings are already allowed to be recorded. So information and data is already being recorded and collected, and that doesn't change the nature and character of the courts. So I don't believe that recording anonymized data from these same proceedings would change the nature and character of them.
Okay, thanks. Senator
Mr. Chair,
Deeds.
can I ask a question? I mean, aren't you afraid that by this last sentence in the purpose section, which will appear right after the definitional section, 119, in that section, because that will be in conflict with the statutes where there's a presumption against bond? Or
So we don't believe so, Senator. I think to the extent that in the code, it already exists language that should function as a presumption favoring release more generally, and that's the purpose section here that's been added. A presumption favoring release more generally, then to be read specifically with the various subsections that exist.
Yes, ma'am, I agree with that. I'm concerned generally, we don't have purpose sections in bills. Generally, and I'm concerned that specific language might be read in conflict with other existing law.
And Mr. Chair, if the committee wants to strike that language, I'm not gonna.
Okay, is there a motion to strike that language? Okay, it's moved and seconded to strike the line under 19.2-19.1, purpose, the whole purpose section.
It's basically going to be a title amendment because you're going to take 19.2-119 out of the bill.
Right.
And then strike lines 14 through 18.
Lines 14 through 18. Got that? All in favor of the motion to do that, say aye. Aye. All opposed, no. Motion carries. Purpose is out. Okay.
Thank you, and I'll defer to Mr. Hughes.
Okay.
Good evening, Mr. Chairman, committee members. My name is Gary Hughes. I represent the Virginia Community Criminal Justice Association. Our memberships are comprised of local probation pretrial officers. We support the bill. We support ongoing uniform data collection. We feel this is going to help all of us make more informed, make better policy decisions. As a director of an agency, for me, having more data is better. I appreciate there may be a lift in getting there, but we need to start somewhere in terms of improving data collection for Virginia. This is a very good start for us. Okay. I'd encourage some patience in implementation. Speaking very briefly to Senator Openshain earlier in the Crime Commission study, we greatly appreciate the data from that data cohort from October of 2017, and we look forward to receiving more of that data and learning from it. But that is a static point in time. That is a 1-month data collection. I know the study was 15 months, but we're already about 2.5 years from that data. We'd like to see ongoing data collection. It's going to help us make better decisions. Okay. And thank you for your time.
Yeah, thank you very much.
And are you
Senator Openshain?
DCJS? I do not work for DCJS, sir, no. I am a director for Chesterfield Colonial Heights Community Correction Services, but I'm representing our association.
Okay, thank you.
Okay, next.
Is DCJS here?
DCJS here? All right. Next.
They have the
Good evening,
capacity.
committee. My name is Dominique Martin, a policy analyst at New Virginia Majority. We thank Senator McClellan for introducing this bill. This bill is very important to us. If you don't know, we have our own Court Watch program that does this type of research on their own as of now, but there are a lot of disparities that they notice just at their own kind of local level. So we do think that this is something that needs to be expanded to statewide level to get better information about what exactly is going on. This would have, the data would have great ramifications for indigent populations. We know that a lot of people that do get accused of crimes are indigent and can't afford bail, and sometimes they're being held just for the simple fact that they can't afford bond. So we do think that this information is absolutely necessary and do hope that you support the bill. And thank you, Senator, for introducing it.
Next, and we got some, time's expired, but go ahead.
Good evening, Chairman. Thank you so much.
Bill's in good shape, go ahead.
Thank you. My name is Ashna Khanna, and I'm the Legislative Director for the ACLU of Virginia. We strongly support restoring the presumption of innocence to our criminal justice system. We must end the practices of holding people in jail who have not been convicted of a crime and are not a risk to public safety. Scrutiny of pretrial practices in Virginia is long overdue. Though little public information exists about statewide pretrial outcomes, what we already know from the Crime Commission is deeply troubling. We believe that pretrial justice starts with transparency, and we strongly support the bill and Senator McClellan.
Okay, thank you. Is there anybody else want to speak? Is there a motion?
Move to report.
The motion is made to report the substitute and refer to finance. All in favor, then second, all in favor say, vote aye. All opposed, no. I don't know how to do that. Yeah.
You do it up here.
I see. Cancel, okay.
Yes.
Okay. And cancel.
That's 13-0.
Okay. 13-0. I can't, he's left. Okay. Okay, 13-0, the motion, the bill has been reported and re-referred to finance. Okay, next bill is 818, Senator Morsi. 818. Senator Morsi? 818. There's a substitute to Senate Bill 818. Motion is made and seconded to adopt the substitute to Senate Bill 818. All in favor say aye. Aye. All opposed, no. Motion carries. Okay, Senator Morsi. Behavioral Health Docket Act.
All right. The genesis of this bill, Mr. Chairman, members of the committee, was the following, that some people, because they're going through the throes of a mental health crisis, should not be on a regular docket, but rather should be either in a mental health docket or a mental health court. So what this bill does is it'll create a new code section, 18.2, 254.3, and it's called the Behavioral Health Docket Act. And it does several things. The goal of this mental health docket in various jurisdictions is to address people that have committed a wrongful act but have some mental health issues. It addresses mental health illness, substance abuse, and other conditions. It establishes behavioral health dockets, which are a subset of criminal court dockets for those people that have mental health issues. There are...
Yeah, Senator Deeds.
It's my understanding that the court has the ability to do this now. Does this change anything or add anything? Or?
Great question. No, the only thing that it does is it codifies what you did, Senator, in 2000, and I believe it was 16. Also, there was a rule of the Virginia Supreme Court, 1:25, that created this, and for reasons that I can't quite explain or articulate, we didn't codify this. So we're codifying it. Should have been done a few years ago. There's nothing novel or new about it. You're very much aware, Senator, that we create state advisory committees and state and local committees. There are, if you look on Section F, the State Behavioral Health Docket Advisory Committee shall be established in the judicial branch, chaired by the Supreme Court. There are various members that will be part of it. The only thing that I would like to do on this bill, and I've spoken, and I'm going to ask that she come up or share some testimony with the panel. Christine Sheen, who's Forensic Operations Manager, she is far more familiar about the establishment of the mental health docket than I am, and gave me some wonderful advice and information. She suggested, and I agree with her. In fact, I was about to say you have the substitute. That's already before you. It's already been deleted. Okay. So let me just, thank you. Why don't I just pause for a moment and let Christine share with you. She's got some institutional knowledge, and then I'll come back to answer any questions.
And while you come up, I have a question. I got a call this afternoon from one of our General District Court judges in the Roanoke area, Jackie Talevi, who's done a good job with mental health. You probably know her. And she just simply said she had concerns, and I don't know what they are, but I just got it late this afternoon. So if you know her, or you know what the concerns might be, I'd like to have some insight.
Good evening. My name is Christine Shine. I'm with Department of Behavioral Health and Developmental Services. The administration has not taken a position on this bill. However, it appears to be consistent with what's currently taking place in Virginia and provides a framework for dockets. I don't know I haven't spoken to Judge Talevi, so I'm not sure what.
Do you know her?
I know who she is.
Could you call her and try to find out what her concern is? Because I'm not sure I'm going to get back to her.
Yes, sir. There is somebody on my team that is on the State Advisory Committee, so we can speak with her, certainly.
Okay. All right. Thank you. Does Supreme Court have
Thank you.
Concerns or ideas?
Thank you, Senator. And thank you, Senators. And I believe Senator Deeds touched on what I was going to say, is that the Supreme Court, we have these dockets already in place, and that was promulgated by Rule 125. And to give senators an idea of where we are, we just completed, in 2019 was the first fiscal year where we begin to get the reports on how these committees are going, okay? So back then, we had 69 participants as active, 15 graduating within the first fiscal year from these behavioral health dockets. So the dockets are being developed by the court, and there hasn't been a lot of time that has elapsed since the promulgation of the rule and the creation of these dockets. And we are, the court is moving and establishing these dockets. So it's already there. We already have that in place. There was an additional concern, though, along with not only being in place, and I skipped down to line 99, and Senator Morrissey represented this as well when he was speaking. The throes of a mental health crisis, then his case will be assigned to the behavioral health docket, and he will not be subject to incarceration. I attempted to find defining that term, and I didn't find it referenced anywhere else in the code. And additionally, the guidance of will not be subject to incarceration, a concern is it may run afoul of what the rules promulgated in establishing the behavioral dockets may be.
Excuse me, if I can just interrupt for a second. There was a substitute that addressed that, and I think we've already ruled on the substitute.
I apologize, I
okay.
didn't have the
was just done
substitute
So
on.
what, it changed from what to what?
It now reads, and it should read, if there is cause for concern that a defendant was experiencing a crisis related to mental health or substance abuse disorder, then his case will be referred to a behavioral health docket to determine eligibility for participation.
That's been deleted?
That's.
And if it says to determine eligibility, then.
My only concern about this bill is I don't want anything to stifle what's happening right now. If this bill is gonna help us develop more these specialty dockets, I say go for it. And that language would probably be different than what we've done before, but this language looks like it's pretty close to practice, isn't it?
Yes, I can assure you,
Yeah.
Senator Deeds, it's not stifling that which has been established in the last 3.5, 4 years. Best way of saying is what I said before. It codifies what you were done, and normally one would expect that this would be codified first, and then we'd start. Let me just say this. There are 11 operational behavioral mental health dockets right now. We actually have 3 in Richmond, and Juvenile Domestic Relations Court, Circuit Court, and General District Court. I'd like to see more throughout the Commonwealth.
So could you tell me what language was deleted?
Mr. Chair, paragraph J, which was on lines 99 through 102, is substantially different, and now in the substitutes on lines 90 through 92.
I see.
And it basically not in the original bill, that would indicate that if you were in a mental health crisis, you had to go through the docket. And this says that you're going to be referred to the docket to determine whether you're eligible.
Right.
But it doesn't mandate anything except.
Deletes the language that shall not be incarcerated, that's deleted. Okay.
Looking at this bill, the substitute, Mr. Chair, what I'd like to do is go ahead and report this and refer it to finance. And I'd like for the Supreme Court to look over the substitute over the next day, next day or so, and see if this is gonna mess anything up that you all are already doing, come tell us.
Yes, sir.
But I think it's a good idea to put this in code and make sure.
Okay. Is there anybody else who'd like to speak on the bill, or for or against? Is there any further question? Is there a motion?
I'd move that we report and re-refer to finance.
It's been moved and seconded that the substitute, we did adopt the substitute.
Yes, we did.
Be reported and re-referred to finance. All in favor, vote aye. All opposed, vote no.
Mr. Chairman, did you do me?
I can't vote Sasslaw since he's left.
Thank you.
Cancel the proxy. No. I'll do it.
Thank you, Mr. Chair.
13-0.
right, 13 to 0, the motion carries. Okay, the next bill is 819, Senator Morrissey.
Senator Morrissey, 819.
19.
819, and this is Drug Treatment Court Act.
If you want, I can do Norman and Costco, 607 and 195.
Okay.
And I think there's a total piece.
All right. Give me about 30 seconds, and then after that, I'm going to make a suggestion on what I would like to do with this, Mr. Chairman.
Okay.
This bill, 819, provides that any jurisdiction or jurisdictions that are desirous of establishing a drug court shall not be denied permission to establish that drug court just because the funding isn't there. It would also, the bill would make available to a defendant who is desirous of going into a drug court that he would have that opportunity. There are a number of drug courts in the Commonwealth, but there's not a drug court in every jurisdiction that wants to have that.
Yeah.
So what I did is I sent out letters to a number of people asking them to weigh in, and I had the opportunity to speak with the Office of the Executive OES, and I spoke with Mr. Haid, and here are a couple of comments
Mr.
that I got.
Chairman?
Yeah, Senator Obenchain.
Given that the fiscal impact on this is only $48 million, I move to report and re-refer to finance.
All right, just a minute.
Bear with me for one moment. I'm winding down, but
Quickly.
A number of people said that we need to have some other folks take a look at it, and the OES said that they wanted to do that. And I think what I'd like to do is follow the recommendation of Mr. Haid, and that is request that the Drug Court Advisory Committee review this and that it be carried over till next year.
Okay. Second, is moved and second.
Took a long time for me to get to
Carry
that
it
point.
over to next year. All in favor of the motion, vote aye. All opposed, no.
Yes,
We
sir.
really like these kinds of bills to carry it over. 13 to 0, okay. The motion carries. Senator, do you have any more? Huh? What? Yeah, all right, let's do, I think we've already done your fiscal impact bill, so, yeah, 607, Senator Norman.
And 195, we've got a substitute.
In the name of Senator Obenchain. Okay.
All right, so first I would move adoption of the substitute.
Is there a second? All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Motion carries. You don't.
It's a recorded vote because we're rolling in.
Oh, okay, wait, we're rolling 607. What are we rolling in? 195 into 607.
Mr.
Okay.
Chairman, members of the committee.
All in favor of the motion, vote aye. Okay. Yeah. Okay.
Mr. Chairman,
Just
members of the committee.
The motion carries 13-0. Okay, it's been rolled in.
This will be a familiar bill to most of you. This is the statute of limitations bill for actions against contractors by the state of Virginia. You may remember last year we had extensive discussion about the fact that there is no statute of limitations. So 10, 20, 30 years down the line, the Commonwealth can file a breach of contract or breach of warranty action against a contractor alleging defective construction. Last year, this bill came out in a slightly different form with a 10-year statute of limitations, if I recall accurately. It passed the Senate Courts Committee 13-0 with one abstention, passed Finance Committee 15-0 to 1, passed the Senate 39-0 to 1, only to die a painful death in the House Appropriations Committee. This year, Senator Norment and Senator Cosgrove worked with the Association of General Contractors and with the Secretary of the Administration. My understanding is that this substitute represents a compromise, inserting a 15-year statute of limitations. Mr. Nolan is here. I think somebody from the Secretary of the Commonwealth is here to indicate perhaps there is peace in the valley at last.
Yes, Mr. Chairman, Chris Nolan with McGuire Woods on behalf of the Associated General Contractors, and we, along with the Associated Building Contractors, Virginia Transportation Construction Alliance, and the architects and engineers who are here as well, have worked with DGS to come up with this bill that you have before you. We are all in agreement on this, and it's compromise on both sides.
Sounds good.
And
Anybody
Mr.
else? Yes, Senator Obenchain.
Mr. D'Amico, Director of DGS.
Mr. Chairman, committee members, Joe D'Amico with the Department of General Services. We spent the better part of a year working with the private sector stakeholders on this bill. We like the substitute, and we've worked through it, so DGS is good with the language in the substitute.
Okay, good. Anybody else want to say anything about the bill?
Mr. Chairman.
Mr. Albro, would you like to?
Chris said it for me.
Okay.
He
All
said
right.
it better.
Yeah, Senator Shervill.
I just had a question. I guess I voted for this last year without understanding what it did. So, is this rule different than for private sector?
Yes.
Yes. And why is that? Can somebody explain to me why?
Well, it is a compromise because the current rule is there is no statute of limitations. This applies a 15-year statute of limitations. The private sector rule would be, if it's a written contract, 5 years, but the concerns about the sovereign and the public purse led to a protracted debate about how to prudently modify this in a manner that protects the public purse and the sovereignty of the Commonwealth. And this is the compromise that was hammered out by the parties over that time.
It used to be you could, the sovereign cannot be sued, but here the sovereign can sue anybody just about.
Mr. Chairman, so I'm
As
clear.
long as, whenever he wants to.
Is there's a rule that says the sovereign can sue for a building whenever it feels like it?
Yep, Mr. Chairman, again, Chris Nolan. Senator, there was a case about 3 years ago called Hensel Phelps. It's a Virginia Supreme Court case, and it involved Hokie stone. And in fact, I think it was 13 or 14 years after the building was built, the stone failed, even though it was built according to the specifications of the university.
Lane Stadium.
That suit was brought, and in that case, the court articulated this premise that, in fact, the king is the king,
Right.
and the king
It's
can
good
do
to be
no
the
wrong.
king.
Correct. Since that time, the contractor community and the design community see this as a significant risk, and that's why 15 years is better than infinity, and that's why we agreed to this
You don't
in
like
the bill.
infinity, huh? Okay.
It's hard to price risk at an infinity, yes.
It is. Okay, is there a motion?
I move to report.
Is there a second? All in favor of the motion to adopt to report the substitute, doesn't have to need to go to finance, report the substitute, say aye. Vote aye. All opposed, vote no.
It's 13-0.
It's 13-0. The motion, the bill is reported. Okay. Which one? Okay, 973 is my bill. I'd like to move to carry it over for the year. This has to do with the fact that Roanoke City needs a fifth General District Court judge, but I think we need to carry it over for the year in order to do the arithmetic. All in favor of the motion to carry over for the year the substitute to Senate Bill 973. All in favor say aye. Aye. All opposed, no. Vote no. Okay. Is Senator Stewart come out? Okay. All right. Okay.
Ayes 13, no 0.
Ayes 13, noes 0. Okay, thank you very much. Okay, Stewart's bill. Can we talk about him without his being here? I guess we can. And we talk about him when he's not here anyway, don't we? No, seriously. Okay.
Mr. Chair, there is a substitute for Senate Bill 930. Basically, the substitute just changes the bill to have the Secretary of Human Health and Resources convene a work group to study the feasibility of establishing and maintaining a 24-hour, 7-day-a-week toll-free mental health crisis intervention hotline and developing and implementing policies and procedures for referring tips through that hotline to law enforcement. It asks that the work group recommend specific legislative, regulatory, and budgetary changes needed to implement the work group's recommendation. And it asks that a report be delivered back to the General Assembly by December 1st, 2020, and to the governor.
Yeah. Okay, any questions? Is there a motion to adopt the substitute? We haven't done that, have we? All in favor of the motion to adopt the substitute to Senate Bill 930? All in favor say aye. All opposed, no. Motion carries. Okay, this is a Section 1 bill. It's been explained. Is there any discussion?
Mr. Chair, the only thing I would wonder is if the language is so narrow, you're only looking to receive on the hotline to receive anonymous tips. What about people that need help or people that are contemplating suicide? There are lots of reasons why you might want to have a 24-hour set call line available, but it shouldn't just be to receive tips. People that need help ought to be able to call it too.
Mr. Chairman, I think Senator Stewart would probably be receptive to that amendment, but I can't speak for him, and this bill needs to go to finance.
So moved.
Okay,
We'll fix it in finance.
report and re-refer to
All
finance.
right, the motion's been made that the substitute be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no.
That's the last bill in that block, is that right, Mr.
Yes, yeah.
Ayes 13, no 0.
Okay. Now, with
45 to go.
We, 47 to go.
No, we already
before
got rid
have
of
to go home. Now, we finished the bills with fiscal impact in the subcommittee, so now we're moving to patrons who are not on the committee, and I think we have a couple of them. Senator Favola.
Thank you, Mr. Chairman. I have two very simple bills. And you heard them before. So first bill is Senate Bill 938. I do not have a substitute or even a line amendment. What this bill does is it increases the fees that would be collected by the clerks of the court by $2. And it also provides for a larger chunk of that fee to go to the Library of Virginia to pay the cost of archiving and indexing certain records. There actually would be a fiscal benefit to the state, and that was a question asked by Senator McDougal. And Mr. Dix tells me that the fiscal benefit would be approximately $2.5 million
Mr. Chairman.
to the state.
Yeah, Senator McDougal.
My question is, how much of the circuit court clerks going to collect from this $2 fee? How much, not how much are they going to actually collect and remit to the state? How much are they going to actually benefit?
Oh, how much are they going to keep?
Yes.
Is that your question? Okay, Mr. Dix can answer that question.
Mr. Chairman, Chip Dix on behalf of the clerks. 100% of the money goes to the Library of Virginia.
Mr. Chairman,
Yeah,
that was
Senator McDougal.
my biggest concern when we were here last time. We put a tremendous amount of burden on our clerks. We're collecting more money to help them, but they're having to collect it, they're having to do more, but they're not getting any benefit.
I have another bill that will help them. I have a second bill that'll help the clerks of the court monetarily. And actually, the clerks of the court requested that I carry both of these bills. There was some concern that they really do want the records properly preserved at the Library of Virginia, and money is needed to ensure that we have the latest technology and the best equipment possible to keep records.
Shouldn't we use the general fund to help the library do these things?
You do use the general fund, but this is going to increase money to the general
Why
fund.
don't we just
Mr.
appropriate more money from the general fund? Yeah, Senator.
You could.
Yeah,
I mean,
Senator
that's-
McClellan.
Yeah, Mr. Chair.
You could.
To be clear, the records that the library is keeping that this is going to fund are local court records.
Yes, yes,
Okay.
that is absolutely correct.
Thank you.
Any discussion? Okay. Is there a motion? Been moved and seconded to report the bill. All in favor, vote aye. Reluctantly.
Happily, there was more money coming to the state.
Well, I don't think that's a good way to collect. You're adding fees to people who go to court.
Ayes 8, noes 5.
But I voted with you. Okay. Reluctantly. Okay, the next bill is
Well, thank you.
940.
Yes, 940.
Senator
And
Favola.
thank you, Mr. Chairman. This bill increases the fees that the clerks of the court will collect from $2 to $5 for the lodging and indexing of wills. And experts tell me that I guess the clerks of the court are not indexing many wills because people are not necessarily filing them with the clerks of the court. They're keeping them in their own thing, but.
Chair,
Yeah, Senator
last I
Deeds.
checked, it was still a Class 1 misdemeanor not to record a will. Is that not right? Is that
No,
not
I don't.
correct?
Willfully not to record a will.
Mr. Chairman, Chip Dix on behalf of the clerks. I believe that it is if you willfully don't record, but if you record, this fee has not been increased since 1956. And so it's $2 to $5, and most clerks today don't lodge many wills because people don't bring their wills to the courthouse, because most estate lawyers say what you should do is keep your will at home instead of putting it in the courthouse or in a trust department. So
You're not talking about recording a will and it's not being probated. You're talking about somebody that wants to store their will at the clerk's office.
that is correct.
That's correct, indexing and preserving.
To lodge the will.
Okay,
Mr. Chairman.
Yes, Senator McDougal.
This is totally voluntary. If somebody doesn't want to do it, they don't have to do it. It's not
That's right.
like probating a will, move to report.
All right, Senator
Thank you.
Morrissey.
Obenshain, it's getting late and I'm getting a little frazzled. What was the language of the bill that you had regarding a require that something be indexed with a clerk of the court to prevent fraud?
Let me talk to you offline. This doesn't affect it.
No, that's no.
I don't want to slow this down.
Simple fee.
Okay, it has been moved, is a motion to move and second to report the bill. Is there such a motion? Yes, Senator Deeds moves to report the bill. Senator Morrissey seconds the motion. All in favor, vote aye. All opposed, vote no.
This was the simplest bill you've heard since I've been here.
That's a good bill.
Thank you.
That's a good
Thank you. All right.
Okay, now who else? Senator Lewis, who's next? Who is next? I got Senator Kiggins here, okay. Senator Kiggins, in order. Okay?
Mr. Chair, members of the committee, I have Senate Bill 396, which we discussed last week, and we have a substitute to present.
396. And this was last week. Okay, we now have a substitute. Is there a motion to adopt the substitute? Senator Deeds moves and Senator Shervill seconds the motion to
Okay.
adopt the substitute. All in favor say aye. Aye. All opposed, no. Motion carries. Okay, we got the substitute before us. Senator Kiggins.
Mr. Chair, the substitute just delineates where, when a locality may appoint and train the local government employees to enforce the local ordinances by issuing summonsing and what type of summons. So it was not specific last week, and you all requested a little more detail. So we did that, and I believe we have someone from the city of Norfolk to
Okay, somebody
speak
from
to
Norfolk.
the exact changes.
Hello, somebody from Norfolk.
Mr. Chairman, members of the committee, Thelma Drake from the city of Norfolk.
Welcome, Delegate Drake.
Well, thank you, sir.
Congresswoman Drake.
Thank you.
And Director of DRPT Drake.
Well, first, I'd like to thank Charles because we did get all of that information on the different code sections, and he's put it here into the substitute so you can see what areas of the law we're able to issue these summonses in. That was your question last week. What was that, and limiting it to what we do. There are also some sections we do by charter authority They're not in here. I think Charles just thought this was state code authority that would come in here.
Okay, any questions? Okay, this looks like it's in good shape. Is there a motion?
Mr. Chairman?
Been moved? Yes,
Mr.
Senator
Chairman.
Overchain. Senator McDougal.
The motor vehicle operations and regulations, so is that going to include DUI, reckless driving?
The answer to that is no, sir. There are things in our right-of-way division that they issue different summonses for. I don't know exactly which ones they are in there. Parking violations, towing. We have our own towing department for the city.
Mr.
So
Chairman.
that's where, it's not DUIs.
Mr. Chairman.
Senator Serval.
When I look at lines 24 through 26, it looks to me like it's, in terms of the traffic and towing, it's 15.2900, 15.2 1700, then 46.2 1200 through 1300 at SEC, which I don't, DUIs in 18.2 266.
But there's some stuff.
And most of the traffic
46.2.
offenses are in 800, 46.2 800, which I don't see in here. There's a couple that are in, like, for example, texting while driving is in, I think, 46.2 1300. There's a few traffic offenses in 1200 and 1300 I'm aware of, but the big ones are in 46.2 800 and 18.2.
Mr. Chair, that's correct. The Chapter 12 of 46.2 is abandoned, immobilized, and unattended and trespassing vehicles and parking. That's the chapter it's to. It's not towards the regulation of traffic, which is what Senator Strobel was saying, the 46.2 800 violations, or the motor vehicle safety violations in Chapter 10.
Okay. Any other questions? Okay, is there a motion? Senator Overchain? Is there a motion to, we've already, did we adopt substitute? Okay, a motion to, I thought we did. Motion to adopt the substitute to Senate Bill 396.
Mr.
Moved
Chairman.
and seconded. All in favor of the motion to
Mr.
adopt the
Chairman.
substitute, say aye.
Aye.
Aye. All opposed, no. Yes, Senator Overchain.
And I'm trying to read this real quickly, but does this apply just to Norfolk or?
No, it's everybody.
Statewide?
Statewide.
Mr. Chairman, it is statewide, so it's any locality that has these employees who want to issue summonses for these violations could.
Okay. It's permissive. Okay. All right, any further discussion? Is there a motion? Motion to recommend, to report the substitute to the floor.
Sorry, Mr. Chairman.
Yes, Senator Serval.
I'm sorry. I'm again, reading this more carefully. What this says is, they may appoint and train local government employees to enforce local ordinances, and then it says, as well as the following. And the issue that I think Senator McDougal raises is that Fairfax County has adopted an ordinance incorporating DUI, reckless, and all this other stuff. So this does bring all that in if a locality's adopted that ordinance. And so, this does give them the authority to do DUI, reckless, all that. The way I read it.
Mr. Chair.
Yes, yeah, Charles?
I think to clarify it, there are two mechanisms in which the locality can do this. One is pursuant to the power expressly authorized to the locality in its charter, which charters would have to be approved by the General Assembly. So it would be the General Assembly granting that authority through the charter of the locality, or as well as in the following categories. So for the DUIs, if the DUI authority was in a locality's charter, then yes, the locality could enforce it. Otherwise, if it is not in that locality's charter, it is limited to the enumerated list of code sections or chapters in this bill.
Mr. Chairman.
Okay, Senator Morrissey.
And I think that if I have this wrong, staff will correct me, but many jurisdictions, many cities, many counties have in their either the city in its own charter the right to issue summons for certain offenses, including, as Senator Serval said, DUIs, traffic offenses, et cetera. That's part of it. And there's a reason why sometimes you'll have somebody arrested pursuant to the state code violation of a DUI, and then there's a local ordinance for DUI. But the way I read this, and I agree with Senator Sturville, on line 15 it says, by issuing summons for misdemeanor violations of ordinances expressly authorized to the locality in its charter, which some of these charters allow. Traffic offenses, DUIs, and then it says as well as. If you only wanted to limit it to to those in line 17 at SEC, why don't you say limited to the following?
Or, Mr. Chairman, on line 16, if you simply deleted the words as well as. And perhaps replace it with where.
Limited to waste collection. Which I
And
think
Ms.
that makes sense.
Delete as well as.
Yeah, and you'd put maybe,
Mr.
on line 16, enacted pursuant to
Mr.
a power where expressly authorized to the locality in its charter in the following categories.
Mr. Chairman.
I don't see the word
Senator
charter.
Shervill.
Mr. Chairman, I agree that that amendment would provide a lot of clarity, but I also just want to note that, I'm not saying I necessarily agree with this either, guys. I'm just-
no.
But the other issue is that there's ambiguity in the statute because it talks about a locality and a charter. Not every locality has a charter. And so I think if a judge looked at this, they would have confusion as to whether or not this was intended to apply to a county or not.
I think it's required to have a charter.
Mr.
Chair.
Counties don't have charters.
Senator Deeds.
No, don't look at
One at a
that
time
bill.
now. Senator
That bill
Deeds.
doesn't count.
I'm a little concerned about the way this thing is written, and I'm not sure we can get it fixed right now.
Well-
So I would suggest, I would move we carry the bill over.
No,
to
no,
election.
Mr. Chairman, can I clear something up? Because I
Sure.
think Senator Deeds, you weren't in our subcommittee, and this is the reaction to something that happened in 2014, when all of you did a whole lot of work to deal with special police officers that were granted by charters to be able to do certain things. But what you were working on was reining in private sector security people who acted as law enforcement. Many of you probably
Right,
remember
yeah.
was probably a very big thing that you
ASCOP,
dealt with.
yeah.
So what happened in doing your work there, the authority for a city like Norfolk, who does have this in their charter, was removed. And everyone that I've talked to since November, made several phone calls, including to the patron of the bill on the House side, Department of Criminal Justice Services, who wanted to know why we were making our people go to law enforcement school, which is what they've had to do recently. And what we're trying to do is reestablish the authority that they had prior to 2014. I don't see the word charter on line 15, locality, oh, that's on 16, okay. So what these were things that were in our charter, and our police chief was able to make people special police officers in order to do this. So we're simply trying to get the authority back. If you'd like to limit it, that it can never be DUI, that section of the code, you know, that would be fine with us. But what we're trying to do is to do what we've always done. We have had this in our charter since 1958 that we can find. It may go back before that, but
But
1958.
this is limited to
This-
whatever's in the charter. It can't, you have to have a charter.
We have the authority in the charter, and we have the authority in the code. We just need the authority for one of our local employees who does things like building code inspections, zoning people, right-of-way people, that have always issued summonses. And again, they have to go to the class right now and be licensed because they're caught up. John Jones is one I talked to. He was sitting here until a few minutes. He's still there.
Yeah, he's there.
And I wasn't aware of any objection to the bill, but I do appreciate you wanting to limit the bill and clarify the bill, which is what I'd hope we had done with Charles in providing all the code sections
Do you have
that we
an
have.
objection
Mr. Chairman.
to, you have an objection to taking out as well as, so it's limited to
Well,
what's limited?
And some people may have had the old bill before you got the substitute, because that is the change that happened in 2014.
Mr. Chairman.
Yeah, Senator Shervill.
Mr. Chairman, I'm just not, if this is a Norfolk issue, I'm not clear why we're not just amending the Norfolk Charter. I mean, we're giving authority to 400 jurisdictions here with this, and the statute is written as now ambiguous, and by the way, it was special conservators of the peace, not special police, which are
But
different.
that was the line that was taken out in the original in 2014, and Senator Kiggins has a copy, and I have a copy of that
It seems to me this is a
language.
charter amendment. It's what it should be.
Well,
yes. Senator Obenchain.
Can we just, though, keep the charter language and strike the rest? And this will progress, and perhaps it can be fixed.
What
The
do you-
chairman will
what do you mean?
ultimately be appointing a conference committee if it moves on.
is there a motion to delete as
I
well
move to
as?
delete the rest.
It's been moved
Can,
and seconded to delete the
Everything
language
after
on
the charter.
line 16 that says as well as, after the word in its charter, delete as well as in the following. So it goes in its charter in the following categories. That's the motion?
That's the motion.
Okay, all in favor of the motion, say aye. Aye. All opposed, no?
No.
All right, that's been.
Mr.
motion
Chair, I do
carries.
think that
Yeah.
the proper amendment would to leave the last sentence in there of such employees shall not have the power and authority of constables and limited to summonses and locality. I think you'd want to keep that last sentence.
I agree. That's my motion.
oh,
To keep,
but
what's your motion?
will this give us the authority to issue the summonses?
The motion is to do what?
Okay.
The
Okay.
motion is to strike on line 16 after charter
Everything?
and keep the last sentence beginning on line 32, beginning such employees. That's my motion, right,
Yeah.
Charles?
Yeah,
That's correct, Mr.
That's
Chairman.
fine. Oh,
All right, this is line 16, do what?
Mr. Chairman, strike on line 16 after the word charter, strike as well as through line 32, ending with title 62.1. Strike all of that language.
Everything to the last sentence, right?
Yes, sir.
Okay.
Mr.
All right.
Chairman?
Thank you.
Yeah, Senator Boysko.
Is there anybody from VML here who might?
Anybody
speak
from
to this?
VML?
I don't know if any of them are here, but they've been very involved in this discussion since November. So they actually been very involved and have approved this language and like this better than any of our other versions. So, I mean, going from November on, so.
I would,
So they are in support of the bill, I can tell you that. Norfolk is a member of VML, and they were the first place I turned when this issue arose.
are you okay with striking everything
Yes,
after
sir.
line 16 all the way down to the last sentence?
Thank you. I just couldn't find it. I've
Yeah.
got a different version of the bill.
Okay.
Thank you.
All right, we got a motion second motion is to strike everything from after charter on line 16, where it'd be a period, everything all the way down to the end of line 32, to the end of that sentence. So it only leaves the last sentence of the bill.
Mr. Chairman, substitute motion.
A substitute motion.
PBI.
Oh,
Passed by indefinitely. All right, is there a
That takes
second?
precedent.
Okay, the motion to pass it by, any statement about that? Okay. Thelma?
Well, we would certainly hope you would not do that, because,
All right.
but
Okay,
it's a
all-
pleasure of the committee.
All in favor of the motion, say aye.
Aye.
All opposed, no? No. All right, let's vote on it. All in favor of PBI, vote aye or no.
Ayes 5, noes 8.
Move to report.
Okay, 5 to 8, okay, it
Or the
fails.
MAMendment.
Now we got have we
The
done? this?
amendment had been
Amendment?
adopted.
Mr. Chair.
All right, motion, yes,
Question.
Senator McClellan.
Is this a problem anywhere other than Norfolk?
Pardon?
Is this a problem, the problem you're trying to solve? Is it a problem anywhere other than the city of Norfolk?
There are other cities, and it is permissive. And you saw in it that they have no other police powers. We have one local government I've talked to who wants to be able to arrest, so they want to send their people to law enforcement. It's not a big problem. It's a huge problem for Norfolk, but there are other localities that do this and other localities that do it in a different way.
Mr. Chairman, this does
So-
not, Mr. Chairman,
Yeah, Senator Obershine.
this does not give power to arrest, though.
No,
But it,
No.
well,
It's just summons, that's all.
no other police powers than actually issuing the document.
Okay, we got a motion to delete everything past line 16 to the end of line 32. That's a motion? We haven't
Yes.
voted on it, have we?
I wonder why.
Have we voted on that, John?
Can you read that?
Do we vote on that motion? I don't think so. Okay, we have a motion
To amend.
to amend the bill to delete again everything from the line 16 at the end of the word charter, put a period there, and everything all the way down from line 16 down to the end of line 32, and into the final sentence of the bill. Okay? All right, all in favor of the motion, say aye.
Aye.
All opposed, no.
No.
Let's vote. All in favor, vote for the amendment, vote aye. All opposed, vote no. Okay.
Ayes 8, noes 4, 1 abstention.
Mr. Chairman,
move to
Okay,
report.
Senator Morsi.
we've just amended it. Can you read slowly, it's getting late, just the new language in this?
Mr. Chairman, the new language would read, notwithstanding any other provision of law, a locality may appoint and train local government employees to enforce local ordinances by issuing summonses for misdemeanor violations of ordinances enacted pursuant to a power expressly authorized to the locality in its charter.
Speaking to that amendment.
I'm not finished yet.
Oh, I'm sorry.
Such employees shall not have the power or authority of constables at common law. Their power should be limited to issuing such summonses in their locality.
Okay. Speaking to that.
Yeah, Senator Morsi.
So here's what you've just done. You've said that any locality in the Commonwealth of Virginia may appoint and train a local government employee, train a local employee to enforce ordinances as established by whatever those ordinances are. And it is not limited to a certain category. It could include traffic offenses, DUI, et cetera. And that is not assuaged by that last sentence that says, such employees shall not have the power and authority of constables at common law. Their power shall be limited to issuing such summons in the locality. I get it. They can't arrest him. They can't put him in handcuffs. They can't take him in. But you know what they can do? A local employee that's trained can issue a summons. That's called an arrest for someone that's allegedly committed a DUI offense. That's respectfully, I can't agree to that.
Move to report.
All right, it's been moved. Is there a second?
Bill. Senator Norman seconds.
We had.
I don't know that
John Garrett,
you can
I
second
swear.
unless he's here. Is there a second? Okay, it fails for lack of a second. Second. All right, second. All right, so moved and seconded that the bill should be reported. All in favor, vote aye. All opposed, no.
Ayes 5, noes 8.
5 to 8.
Thank you very much.
Thanks for your effort. Okay. The next, let's see, we have Senator Mason.
Sir.
Next in order.
That's arresting somebody for DUI.
Thank you, Mr. Chairman, members of the committee. It is Senate Bill 1072, and there is a substitute.
1072.
Yes, sir.
For both charging instruments.
Okay. Is there a substitute? Okay.
Exactly.
Fortunately, I have a
Yes.
good lawyer.
Exactly.
Yeah, no fun. This has nothing to do with fencing streams.
Okay, explain. the bill.
So I'd like to thank Ms.
First of all-
Walsh, Mr.
first of all,
Benjamin,
there's
and
a
Ms.
motion to be made and seconded to adopt the substitute. All in favor, say aye. Aye. All opposed, no. Motion carries.
So as you recall, I came to talk to you about attorneys that come to the court on behalf of the hospital to try to discharge a patient and then being assigned a guardian. Okay, so with the help of Ms. Walsh, Mr. Benjamin, Ms. Patton of the Office of the Executive Secretary, they came up with some questions. First would be, how would the judge know? So on lines 32 to 39, we tried to address. How would the judge know? What time period were you talking about? But the OES also brought me, Senator Deeds in his area, certainly in the last 3 years representing the hospital. And maybe he's the best guardian on the spot. So we tried to adjust, except for good cause shown in a rural area, where for that case, there may be no other option. We're trying to stop the mass numbers of this being done that was brought to light by a Richmond Times-Dispatch article in Richmond.
Okay, any questions?
Yeah, Mr. Chairman. Mr. Chairman.
Yeah, Senator Sherwood.
Sorry. So, and I appreciate the senator sent me some of this language.
Yes, sir.
And I forwarded what he said to a friend of mine that used to do a lot of this work before he was given a robe. And his response to me was that he thought that a lot of the issues that arise in these circumstances are because there's no mechanism for the guardian to get compensated. So that what often happens is the hospital is the one who's paying the guardian's fees to facilitate the process. And that sort of, in a lot of ways, drives the conflict. And so I'm not, this person also told me that he thought it sounded like a legal conflict of interest. The situation described in the article that you're trying to fix.
Yes, sir.
And that what we're doing here is sort of codifying an attorney conflict of interest in the code. But that the remaining problem still is that there's nobody to pay the guardian's fees. And he said it's very hard to find lawyers that are willing to represent indigent hospital people for free. And he thought that's the real problem, is where the money comes from.
Well, Mr. Chairman, and
Senator Oberchain.
And Senator Servell makes a very good point. I mean, it is a bit like the tripartite relationship that exists for insurance companies and their counsel who are hired to represent a defendant in a civil action. Conflict may exist, but the law basically is very clear that the duty of the lawyer who is retained lies with the defendant they are hired to defend. It's a matter of contract, a mixed matter of contract and legal ethics, and I don't know whether there's any easy way to allow the hospital to pay the lawyer who's appointed as guardian and make it clear that the primary duty of that guardian lies to the respondent, not to the hospital. But that would be the logical fix. Treat it much like the insurance company, the three-way relationship exists there, because very often there is a conflict between counsel or between the insured and the insurance company, and counsel certainly has to always resolve that in favor of the insured.
Yeah. Okay. Any other questions? My concern is you've got 3 calendar years, and I don't think this is workable. I think the problem really is probably getting paid. Yeah. Senator Morrissey.
Mr. Chair, does the patron have any people speaking to this legislation?
Mr. Chairman, Senator Morrissey, no, sir.
Okay. All right. When it's appropriate, I want to.
Maybe, I mean, OES may be
We
here,
got a
but,
bunch of bills
I don't know
here,
if they
folks. We could be here to midnight, so go
All right,
ahead.
let me just be brief. Oh, here we go. Of all the legislation that I've seen that's come before this committee, this is, in my opinion, one of the most important pieces to correct one of the greatest ills that I've seen, and that is what we discussed the other day.
Yes.
I can't emphasize in strong enough language what lines 32 and 39 attempt to correct. And for those folks on the panel that weren't here last time, this is what occurred. We had a major hospital in this city that had indigent patients in there. They were taking up bed space. The hospital hired the attorney who went to court and became the guardian of that individual for the sole purpose of removing him from that hospital and putting him into a nursing home. Notwithstanding that there were family members in at least 2 instances. This was an expose in the RTD, 10,000-word expose, where the family member said, I want to be that guardian. To add insult to injury, after that attorney was appointed guardian and then acted in the capacity to move him out of the hospital, then he abrogated, or he was relieved of his duties and responsibilities. It was a horrific situation, and I think that this bill serves to correct that, and I hope that the panel can jump on board.
Mr.
Chairman.
Mr. Chairman.
Wait, one at a time. Senator McClellan.
Thank you, Mr. Chairman. And to further amplify, this is not a situation where VCU is paying the guardian because otherwise the guardian will get paid. This is a routine practice where retained counsel for VCU health system is routinely, when petitions are brought to the court, also becomes the guardian for the patient. And so this is, this is not a situation where VCU is just saying, well, we will get a guardian ad litem and then we will pay them. It is the same person in every single case who is representing VCU, bringing the petitions to be able to get these patients out of the hospital and put them in a long-term facility, and then it is appointed their guardian.
Mr. Chairman?
Yes, Senator.
Nobody is disputing that. Nobody's disputing what Senator McClellan said, or Senator Morrissey, or Senator Mason. Senator Servell just has a very good practical point. Who's gonna be hired? Who is gonna pay the guardian ad litem? Who is gonna accept that assignment? We have a big problem, particularly in rural parts of the state, not having people who are willing to accept assignments as guardian ad litem. This doesn't provide a mechanism for payment.
Go ahead.
Okay, Senator McClellan.
And Mr. Chair, and that is why on line 34, it says, except for good cause shown.
Right, that's what that.
Which is gonna be in every case.
Well,
Maybe in your area.
Well, who in Richmond? I mean, my point is, if the court appoints a guardian ad litem, who pays them? Who pays them?
Okay. All right.
This doesn't say the hospitals to pay them.
Senator Mason.
May I make one point, Mr. Chairman, and Senator Obenshain? The article went on to say another hospital had a chosen law firm that did all this guardian work. Not the firm that brought the patient to on behalf of the hospital, but they picked a firm. The article spoke to judges to pretend to like particular firms to do the work. And in rural areas, it might be one person. But Mr. Chairman, there was also, the point here is, I believe on 13 occasions, when the gentleman did away with his guardianship of the patient, it was with the obligation that if that patient ever came back to the particular hospital we're talking about, that he would be reappointed as the guardian. I'm a layman, gentlemen and ladies. You cannot explain that to me. When asked, would the attorney accept the guardianship of the patient if that patient went back to a different hospital? I believe the response was, I am not familiar with that hospital's process and procedure. Who is that person speaking on behalf of in that case, Mr. Chairman?
Mr. Chairman,
Okay, Senator.
I think I can add something to what Senator Obenshain asked. First of all, as the patron said, it was the same attorney for the hospital each time, hundreds of occasions that went in there. I think it was in Richmond, I think it was the same judge that handled 90% of the cases. And the patron is correct. Not only did he then move him out of the hospital, but as soon as that was done, he was relieved of his guardianship duties, and not in one situation was a family member whose request adhered to. With regard to Senator Obenshain's inquiry, there were a number of attorneys who were willing to step in and do that. They handle guardianship matters. They're appointed by the court to handle it, and are available to do it.
I got a suggestion.
All right, we got to move along. Yeah,
I
Senator
understand.
Obenshain.
Can we just put in here that for good cause shown, the court may order the petitioner to fund the guardian ad litem? So, I mean, this basically would say, can't be their lawyer. It's much like in a divorce case in which one parent can pay, and we have a provision that says guardian ad litem can be appointed, and the court may require the other parent, non-custodial parent, to pay for the guardian ad litem. So for good cause shown, I don't know, the Supreme Court maybe thinks that's a bad idea.
Please weigh in.
Mr. Chairman, members of the committee, Alyssa Patton with the Office of the Executive Secretary. Since we're talking about the guardian ad litem fees, I just wanted to clarify that under the existing code section at 64.2, 2008, if the respondent is indigent, the guardian ad litem fees may be taxed as costs and pursuant to 64.2, 2008, paid by the Commonwealth. So if the estate of the respondent is sufficient, then that would cover the guardian ad litem costs. If the respondent is indigent, then the guardian ad litem, not the council, but the guardian ad litem could be paid by the
But if the
Commonwealth.
hospitals are initiating this process, why should the Commonwealth be stuck with the cost as opposed to the hospital? Shouldn't the hospital bear that cost? And are not indeed there, don't go away, are there not indeed places in the code where the guardian ad litem is required to be paid by one parent or the other?
Well, here you're dealing with a guardian or conservator, not a guardian ad litem, I don't think.
Yes, Senator Rubenstein, and I think the guardian ad litem provisions you're referring to where they're required to be paid by the parent are contained in other provisions within the juvenile code. So these are specific to the petition for appointment of a guardian.
You wouldn't.
Not a guardian ad litem, a guardian or conservator.
Well,
That's what
Right,
the
right.
language
So in a proceeding to appoint a guardian, the guardian ad litem appointed to represent the respondent could be paid by the Commonwealth.
Mr. Chairman, I would make that motion to amend. I think Senator Servell seconded it.
Okay.
Mr. Chair?
Where's that? Go ahead, Senator McClellan.
So would it be possible, and would you consider it a friendly amendment that the hospital's not the entity that chooses who the guardian ad litem is? I mean, I think I'm fine with that as long as
Can you
they're
come with
not the
some
one
word, some
suggesting who the
language?
person is.
And I think that's what the rest of the language says.
Okay, good.
All right,
I
what's your
think
amendment?
Senator Mason's language is fine in terms of defining who can't be a guardian or conservator. All I'm suggesting is a way to arrange for payment that'll actually cause somebody to be willing to step in and serve.
No, Mr. Chairman.
Yeah, go ahead.
Senator Mason's language basically says that the attorney for the hospital can't be the guardian ad litem. I think part of the issue is, though, I think to completely make sure it's fair, that if the hospital is going to pay for the guardian ad litem, the hospital should not be the one to decide who or select who the guardian ad litem is going to be. Because I do think you still could have the same
I'm fine with that. Sure.
repeat guardian who is,
Yeah, I don't object to that.
okay, thank you.
Is there language? Anybody have language?
Kristen can come up with it.
Okay, Kristen. She can
I
come
have
up.
leaned on them to this point, Mr. Chairman.
Well, what we could do is
Sorry.
do it on the floor. If we need to move this along. Is there a motion that
appreciate
we
that.
report with the understanding that Kristen's going to come up with some good language on the floor?
Only if you ask Alyssa to help me.
Can we make this motion to amend in concept? I think
Yeah.
we all understand.
All right, motion is made and seconded in concept, to have an amendment on paying the guardian. All right, all in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Is there a motion that we report the bill
So moved.
to the floor? It's been moved and seconded that we report the bill, the substitute. All in favor of the motion to report the substitute, say aye. Aye. All opposed, no. Motion carries. Okay, thank you. I'm sorry. Yeah, getting late. Okay. Okay.
Thank you, Mr. Chairman, I thank you and the committee
We
very
only
much.
have about 45 more bills, okay? All right, next, we have Senator Chase is next in line. Is she here?
Lewis has been
Okay,
here forever.
Senator Chase, we've received word she'd like the bill to be passed by carried over for the year?
So moved.
Is that it? Is that right? Oh, but for the day, okay, passed by for the day, we'll be here Monday. All right, without objection, Senator Chase's bill will be passed by till Monday. Huh? Okay. Okay, the second, all right, now we have Senator Lewis.
I hate to leave you guys.
Oh, what a shame. Okay,
I've got, first, Mr. Chairman, a little bit of housekeeping. I have Senate Bill 780.
780.
And if I could get the parties to come up. This bill, Mr. Chairman, passed out of general laws unanimously, and I knew before it exited the room that Senator Servell's antennae were going to go up. And I got a text message on this, and from him directly. But anyway, the parties, the campground folks and the trial lawyers have agreed to work with the campground folks to narrow this down as they did with the agritourism folks and the equine folks. So I'd ask that the committee consider carrying it over and let these guys talk for the next several months.
Move and carry the bill.
All right, okay.
Second.
Senate Bill 780
For the
is
record,
carried
it was
over
Open Shane's
for the
antenna.
year? Carried over for the year?
For the year,
Okay,
yes,
all
sir.
in favor of the motion to carry it over for the year, vote aye. All opposed, vote no. 780 is carried over.
8-0.
Okay, Senator Lewis, you have another one?
Yes, one more, Mr. Chairman, Senate Bill 792, and this deals with the Mid-Atlantic Broadband Communities Corporation. I'm sorry, I'm getting a little tongue-tied late in the night, Mr. Chairman. Mid-Atlantic Broadband was founded in 2004, and obviously, as most of you know, they've been instrumental in deploying broadband throughout the rural areas of Virginia. It does not provide telecommunication services, and so for 15 years, NBC worked with VDOT to build fiber optics, to deploy fiber within the VDOT right-of-way. So they were just recently, VDOT just recently determined that since NBC is not a public service company certificated by the State Corporation Commission, it must now pay permit fees and also submit an affidavit to VDOT that NBC has notified every adjoining property owner. So what this bill seeks to do is to reassert what everybody thought had been the status for the last 15 years, that they don't have to do that. And NBC has never had to pay property or permit fees before, nor notify adjoining property owners. And so that's what the bill does.
Mr. Chair, the only question I have is how many other companies like your constituent are out there? I mean, and whether, does VDOT have any concerns about this?
Okay, okay, Delegate?
Mr. Chairman, Preston Brown on behalf of Mid-Atlantic Broadband. This is the only 501c4 organization anywhere in the country that we know of. We've checked, worked with all the stakeholders, VDOT, Comcast, Verizon, telecom industry. Everyone understands this is somewhat housekeeping, and no one has expressed any opposition.
Okay.
Doesn't apply to anyone else.
Any questions of the patron about this Senate Bill 792? Been moved and seconded to report the bill, Senate Bill 792. All in favor of the motion, vote aye. All opposed, vote no.
Thank you, Mr. Chairman.
Okay, thank you very much. Okay, and the next person is
Wait, order pizza.
Mr. Chairman, parliamentary inquiry, when are we going to call this quits?
we're going to go till midnight at least, if not later. All right, until we, well, that's, we got people here that have come to hear the bills. Senator Hashmi. We will be here at 6 o'clock Monday morning unless we can get something more done tonight. We got too many bills. Okay. Okay. Go ahead. Senate Bill 408 is a motion and seconded to adopt the substitute to 408. The motion, all in favor say aye. All opposed, no. Motion carries. Senate Bill 408 is before you, the substitute. All right, tell us about the bill.
Thank you, Mr. Chair. This bill really seeks to address the issue of protecting individuals who are in situations of domestic violence and to give them opportunity to respond to for protective orders. As you know, protective orders have a higher notice requirement for respondents because they can have a significant impact on their lives. However, if the respondent appeals a protective order that's issued against them, the petitioner really doesn't have the same capability of advance notice and response. And so this bill seeks to ensure that someone who has placed a protective order is appropriately notified so that they have opportunity to seek their...
Mr. Chairman, this bill cleans up a situation developed because of a bill I passed last year. I've looked at it. It's a good bill. I think we need to pass it. I move to report.
Any other questions? Okay, it's been moved and seconded that Senate Bill, the substitute of Senate Bill 408 be reported. Any discussion? All in favor of the motion, vote aye. All opposed, no.
Ayes 13,
Okay, 13 to 0.
I guess my
bill-
argument was so convincing. Thank you very much.
You're so good. I wish we had more people that good.
Mr. Chairman?
Okay, yeah, Senator Martin.
I am so grateful that Senator Servo gives us his imprimatur of approval on the bill, letting us know that we can pass it. We need more of that.
Senator Marsden.
Thank you, Mr. Chairman. You have a substitute on this one?
Okay.
It's, excuse me, 10:15.
10:15.
Which is about when y'all are going to get out of here.
Oh, I didn't know this one.
Okay.
This one's a mess.
Senate Bill 10:15. Okay, is there a motion to adopt the substitute to 10:15?
So moved.
Moved and second. All in favor say aye. Aye. All opposed, no. Motion carries. Senate Bill 10:15, the substitute is before you. Is this a marijuana bill?
Yes, sir.
Oh, great. Terrific.
Mr. Chairman, this is protection from prosecution for lawful possession of CBD and THCA oils. As you remember, 5 years ago, we started down this trail to deal with kids with intractable epilepsy, and we came up with the concept of affirmative defense. In other words, it was a sort of, if you did get arrested for it, you could sort of show your recommendation or certification from a physician, and that would be your way out of a prosecution. What this does is attempt to legalize it for those folks who do have the certification. We've already exempted lab workers in this committee from who will be testing these CBD and THC oil products from the 5 processors. And this will add the pharmaceutical workers, the patients, and legal guardians of minors and incapacitated adults, as long as they have the valid certification. It also protects the pharmaceutical, the processor employees from any civil penalties or denying them any privileges or be subject to any discipline actions by professional licensing boards. In other words, the pharmacy, if you're a member of a pharmaceutical association, they can't, go after you for doing these things. But this has already been done for lab workers. This will sort of complete the cycle of those who need to have authority legally to handle these products. We got our first crops coming in the ground, and sometime before June, we'll have these products out, and we just need to protect people. And like I said, we've already done it for the laboratory workers who will be testing these products.
Okay, is there any questions? Is there a motion? It's been moved and seconded that the substitute to Senate Bill 1015 be reported. All in favor of the motion say aye. Vote aye. All opposed vote no. Okay, thank you. Yeah. John?
Ayes 12, no 0, 1 abstention.
12, 0, and 1, the motion carries.
Thank you, Mr.
Yeah,
Chairman.
Thank you. Bill's reported. Thank you. Anybody else can be quick like that? Senator, who else is in the queue? Anybody else in the queue out there?
That's all the nominated committee.
Okay. Well, if we can start going down, Senator McClellan, you have Senate Bill 3 and 67. No, we're going to keep going. We got too many bills.
Senate Bill 3, I believe there's a substitute.
Let's just keep going. I'm sorry, what?
There's a substitute for Senate Bill 3? Yes. So, Senate Bill 3 is the bill that deals with the, I don't have a substitute.
All right, Senate Bill 3, there's a motion and second to adopt the substitute to Senate Bill 3. All in favor of the motion say aye. Aye. All opposed no. Motion carries. You have the Senate substitute to Senate Bill 3 in front of you.
So we heard this some other meeting ago. This is the bill that is trying to deal with the disorderly conduct statute for behavior or conduct at a school or school-sponsored event, which has caused basically a lot of children to be charged with misdemeanors for behavior that is more appropriately handled through the disciplinary process.
Okay.
In the interim, since that meeting, the prosecutors, the defense attorneys, the school board association,
Mr. Chair.
everybody
Yeah, okay.
came together and agreed on this
Mr.
substitute.
Chair, I'd ask Senator McClellan, didn't this bill pass out of the Senate with a pretty healthy vote last year?
It did.
Okay. Is a motion to
Move to report.
report the substitute It's been moved and seconded to report the substitute. All in favor, vote aye. All opposed, vote no.
He should have been here the last time.
Overton?
Yes. Scott?
Okay, all
Yes.
right.
Senate Bill,
13-0, motion carries. The bill has been reported. 67, Senate Bill 67.
yes, Senate Bill 67 would require that the reporting of lost and stolen firearms, and this was basically a bill that has been brought for several years at the request of the police chief of the city of Richmond. At one time, someone from the RPD was here. I don't know that they still are. But basically, this bill, they requested because a lot of times when there is a crime and a gun that has been lost or stolen is used, or they'll have a gun that is traced back to the owner, and the owner will say, oh, that gun was stolen, or I lost that gun. And, but they never reported it. It's very difficult to retrace the chain of custody. And so the police chief requested this bill for several years to help incentivize the reporting of lost and stolen firearms. This is similar to a code section for explosive devices that the counsel for Richmond Police Department knows that code section. I do not know it off the top of my head.
Okay.
That's the
Okay.
bill.
So I guess, Mr. Chair, the only question, I've got Senator McClellan on line 14, it's lawfully possession. If you don't lawfully possess a firearm, but if you, for example, are a convicted felon who hadn't had your rights restored, but you still possess a firearm, and that's stolen, you don't have to report it. Is that right?
And Mr. Chairman, that's correct, but it has to be that way. You can't make somebody report that they've been violating the law.
Under the Fifth Amendment, right.
It's Fifth Amendment protection. That's right.
Mr. Chair,
Yeah, Senator Peterson.
and this may be a question for Secretary Moran. Is there any other piece of personal property that we assess a civil penalty if people don't report it stolen?
Explosive devices.
Explosive devices, okay. How about, say, I didn't realize that was personal property, but how about, say, vehicles, medicine, anything else that if it goes missing, you have to report it? Children? Is there a civil penalty if I don't report my child missing?
Okay.
I
Any
mean,
other
if you'd like to
questions?
bring a bill to do that,
We
can
have the
consider that.
Secretary of Public Safety and Homeland Security here who would like to say a word or two.
Mr. Chairman, members of the committee, thank you very much. Delegate Senator McClellan has explained the bill very well. The Fifth Amendment, you can't compel someone to admit to unlawful possession. It's a civil penalty. And as she has described, this has come at the request of Richmond. Chief Smith was here the other day for several hours, and it has its annual request to their part, and it's one of the a number of the governor's bills with respect to support and recommend for your favorable consideration.
Okay, thank you. Laurie?
Good evening, Lori House with the Coalition to Stop Gun Violence. We support the bill. I also received a phone call from Mayor LeVar Stoney's office late this afternoon that they were unable to be here this evening and requested that I share with you the support of the mayor's office and Police Chief Smith, who was here the other morning. I also would like to share that on the Public Safety Transition Team for incoming Governor Northam at the time, on the Public Safety Committee, numerous law enforcement agencies asked for this. When they go to trace a firearm from a crime scene and they cannot identify the legal owner on this, it leaves the case open. Open cases have been associated with higher rates of violence in certain communities. If we can trace a firearm found at a crime scene to its original owner, there is a much greater chance of closing those cases and those criminal acts. It also just provides penny ante traffickers a means by which to avoid prosecution. When law enforcement trace it to the last legal owner, they say, oops, I lost it. Oops, it was stolen out of the back of my car. Oops, I no longer have it. Certainly, law-abiding citizens and law-abiding firearms do probably already report these. It's persons who, are trying to avoid certain types of crimes and prosecution, and it just feeds the unregulated market in firearms in too many communities.
Okay, thank you.
Thank you.
Mr. Goddard?
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety, for all the reasons given. But I'd also like to point out that this may be a deterrent to straw purchasing. If somebody's going to be straw purchasing firearms, then they're not going to want to keep going down to the police station every time after they've done that to report the thing stolen. Thank you.
Okay. Anybody have a different view?
It feels good to stand up. Philip Van Cleve, Virginia Citizens Defense League. You know, how do you prove when the person knew or should have known a gun was stolen and so forth? We oppose this. Thank you.
Okay. Next.
All right, my name is Maurice Skinner, Senate District 35. I oppose this bill. As a gun owner myself, if someone were to rob me, as soon as I knew about it, I would call the police. It's in my benefit to do that because by reporting that, it lets the police know there's a database. If somebody tries to negotiate or sell that gun or buy that gun through a pawn shop, it'll be flagged and it'll be reported and the criminal would be arrested. So either way, I think that this is just something that's just normal process of a responsible gun owner. Obviously, because of that Fifth Amendment problem, you can't really regulate what it is that illegal owners of firearms do with them. So either way, please oppose this bill.
Okay. Next.
Patricia Webb, Hanover County. This bill would not do what it's intended to do. The simple fact that criminals, people that have guns illegally aren't required to report, plus the fact that if you have somebody that is, say, making straw purchases and a gun shows up at a crime scene and it's traced, you go to the house of the person that bought it and they say, oh, I just now discovered it was stolen. What's to stop that? Absolutely nothing. Law-abiding people report their guns stolen when they're stolen. This bill will do absolutely nothing that it is intended to do. And for that reason, you should reject it. Thank you.
Okay. Next.
Good evening. John Playham, Fluvanna County. I oppose this bill because it makes a victim a criminal right off the bat, you know. And just like he was talking about the car, you know, if somebody steals your car, you don't notice it's gone until it's already had an accident. You know, they come back to you, you know, and then you go, I'm not there. So it's like you're looking for a solution to not a problem, you know. And when does the clock start? When is it on me to sit there and say, oh, a gun's stolen? I'd do it in the first place as soon as I knew. All right? I appreciate it. Thank you.
Mr. Chairman.
Yeah, Senator Overton.
Just if I can make a quick comment, Ms. Haas was, I don't need you, but she talked about the process of what happens when a gun is used in a crime. And I actually can offer a little bit of personal experience. I actually had a gun that was used in a crime. I owned a gun, and I bought it from a licensed federal firearms dealer, and I actually traded it in, sold it back to a federal firearms dealer who sold it. And I got a call about a year later. My stomach sunk, and it was ATF calling to say, you have a gun that was, a gun that you once owned was used in crime. And I said, really? How'd you figure that out? And why are you calling me? I don't own it. It turns out what they did was it has a serial number on it. They take the serial number back to the manufacturer. Manufacturer knows the federal firearms dealer to which it sold it. Federal firearms dealer to which it was sold is required by federal law to maintain a record of the sales that they make. And so as a consequence, they were able to go to the manufacturer and figure out that I was in the chain of ownership. And they asked me, what did you do with the gun? I said, well, I sold it to the same firearms dealer. And they were able to go back and check that, and they follow it. So this is not necessary in order to figure out where the gun came from and where it went. Those records exist. The people who testified about this are exactly right. This is piling on, and it's turning somebody who's a victim of a crime into a criminal just because something was stolen from them. It does not add anything to the power of law enforcement to track a firearm that's been used in crime. So I would hope that we wouldn't pass this, but.
Mr. Chairman.
Yeah, Senator Sherrill.
I was wondering if on line 14 after, if a firearm, we could add, or a shopping cart. No, I'll withdraw the motion.
No. No.
All right, any other discussion? Is there any discussion? Is there a motion? Yeah, Senator Morrissey.
I listened very carefully, as I always do, to Senator Obenshain's example, but I don't think that's what Senator McClellan's bill is dealing with. It's dealing with an individual who had their gun stolen, and it's incumbent upon them to report it stolen. And I don't understand the lady from Hanover, and I'm sorry, I didn't get your last name. Ms. Bremen said that if a law-abiding people report guns stolen, and if that's the case and they do that, I don't understand why any law-abiding citizen like you and the other folks that testified would have any angst with this bill. You're already doing it.
Okay. Well, you've already spoken. Anybody else want to speak on the bill or against the bill? Is there a motion?
Move to report.
It's been moved and it's seconded that the bill be reported. All in favor of the motion to vote, to report the bill, vote aye. All opposed, no. We'll wait. Okay.
Ayes 706.
Ayes 706, the
Would you like
bill
me to do my own?
is reported. You have any more, Senator
Yes,
McClellan?
I do. Senate Bill 711.
I'm going to plan to go to 9 o'clock, okay? So everybody can plan, then we'll go home and go to sleep and wake up bright and early.
All right.
Okay.
Senate Bill 711 would eliminate the mandatory minimum term of confinement in jail for 10 days for a third or subsequent conviction of driving on a suspended license.
Okay.
Do you want to? Yeah, Amy will speak to it because I'm tired.
Okay.
Mr. Chair, committee members, Amy Woolard with Legal Aid Justice Center. This is something that really came out of our work removing or repealing driver's license suspensions for unpaid court debt. When we looked at that data, we looked at driving while suspended charges from 2017 until the end of 2019. They were averaging around $5,700 per month. And right around the time the budget amendment went into effect last July, that removed suspensions for court debt, they dropped to $2,900, which told us many of those driving while suspended charges were court debt suspensions. Even if we repeal that, those folks are going to have those driving while suspended convictions that can stack up to 3. This is a really long look back. It's 3 and 10 years, and then each time, 10 more days. Folks are going to jail for this. They're going to jail for court debt. They're going to continue to go to jail for court debt based on priors for the next 10 years or so. So we hope you support the bill.
Okay. Is anybody, any questions? Anybody have a different view?
Eric Olson, Commonwealth Attorney and Stafford. I don't have a different view. I support the bill. 10-day mandatory minimum for driving suspended is just simply not necessary.
Okay.
Mr. Chair, I propose that we have a substitute and repeal all minimum mandatory sentences.
I have that bill, actually.
I mean,
Okay.
if you think it'll pass.
Go ahead.
Hi, just Dominique, New Virginia Majority, and also speaking on behalf of ACLU, we agree with any mandatory minimum removals.
Okay. Well, let's go ahead and do this one first. And I
Yes.
do have one that repeals all mandatory minimums.
Second.
All right, moved and seconded to report the bill. All in favor, vote aye. All opposed, no.
All right.
Okay.
Ayes 13-0.
Senator McClellan, is there anybody that has people out here would like to speak, that are waiting to speak on a bill? Okay. Senator McClellan, you got two more?
Yes. Senate Bill 721 is one that was brought at the request of the clerks in Hanover County and the city of Richmond, that would provide that an order of restitution will be docketed in the name of the Commonwealth on behalf of a victim, and that the clerk, prior to satisfying the judgment and upon written request of the victim, will enter a judgment in the victim's favor for the amount of unpaid restitution, remove from its automated financial system the amount of the unpaid restitution, and record a release of any judgment. Unfortunately, neither of those clerks could be here, but as they explained it to me, this would help to simplify how they docket and deal with restitution orders and when those have been paid. No one has expressed any opposition to this bill, but those two clerks at least believe they need. Oh,
Here we
okay.
got some, go ahead.
Do you oppose it?
Thank you.
Okay.
I apologize to Senator McClellan. I was in conversation with legislative aid in relaying a simple fact. The lines that the bill here on Senate Bill 721 addresses and assumes that this addresses circuit court restitution orders. And there was a concern from the general district courts concerning their docketing of restitution orders and their relation with the circuit court. And I do apologize again to Senator McClellan. We actually forwarded some emails from the clerk of court in Hanover who originally requested this bill. OES has been in contact with that clerk of court, and he agreed with us to, and I don't, of course, I don't mean to step on any toes, suggested carrying it for a year to allow us to figure out the general district court's relationship with the circuit court and the docketing of these restitution.
All right, well, if the clerk of Hanover agreed to that, then I
Yes.
move that we carry it over.
Okay, is there a motion we carry the bill over for the year? All in favor of the motion, vote aye.
Thank you, Senators.
Thank you.
All opposed, no? Okay.
I did.
Okay. All right, Senator McClellan, 730.
Senate Bill 730, you have heard several years now, but this time I think there's peace in the valley. So Senate Bill 730 would require law enforcement to record custodial interrogations where practicable.
Okay.
This was
Mr. Chairman.
Yeah, Senator Stanley.
That is also my Senate Bill 305, I do believe.
Do you want to roll them together? Are they,
Sure.
it's the same?
They're identical.
Okay.
Okay, the 305 be rolled into 730. Okay. Is there a second? All in favor of the motion, vote aye. Vote aye. All opposed, no. Okay. Thank you. Motion carries.
Okay. So I was saying that the difference between this version and versions you've seen in the past is that over I believe the past year or several months, the Virginia Criminal Justice Conference reviewed this issue, and the language you see here is the language that they were able to reach consensus on. I mean, that's pretty much the bill. I'd be happy to answer any questions.
Mr. Chairman, one slight amendment on line 21, after the words recording of, insert the entirety of.
Okay.
I'll move that amendment.
Second, all in favor of the motion, vote aye, say aye. Aye, opposed, no. Motion carries. What else?
Move to report.
Okay, is there?
Could we, before maybe we move on this here
Would
from
anybody like to speak? Yeah, John, would you like to speak?
Thank you, Mr. Chairman. I'm John Jones, representing the sheriff. We do have some concerns, and let me just say, I worked with the patron. We've done some surveys to the sheriff. We try to do as many of these recordings as we possibly can. I think there'll be some fiscal cost to it, but it seems to go a little bit far. If you look on page 8, on line 18, it talks about a jail, and it kind of makes it makes our people feel like, a statement being made in a jail setting, they are going to be in custody. And there's no question they'll be in custody, so we think it's a little bit too broad there.
We may not be in jail, in other words, it may be
Yeah, I
some
mean,
other
you're
place.
obviously in custody and jail. So our thought on it would be, to address this would be to have DCJS do a model policy, and let's see where we go with it.
Okay,
That would be our preference.
Okay. Senator McClellan, okay. Next. Anybody else speak?
I had a question,
Yeah,
Mr. Chairman.
Go ahead, Senator Sherrill.
This is a question maybe for the patron. I'm curious why we also didn't include it at a school on lines 18 or 19.
All right. Yeah, come on up. Speak.
Yes, thank you. Hi, my name is Haley Cleary. I'm an associate professor of criminal justice at VCU.
Okay.
And my specific area of research expertise is police interrogation.
Okay.
So what I want to share with you today is the research perspective on mandatory electronic recording. Research strongly encourages this as a best practice. Mandatory electronic recording is endorsed by the leading police agencies and professional organizations nationally. Currently, 26 states and the federal government require mandatory electronic recording of interrogations. There are many benefits of this practice for law enforcement, for prosecutors, for defense attorneys, and for the justice system. Recent data show that actually the fiscal cost of recording are quite minimal. And that among the 26 states that already recording in custodial settings, including jails and detentions, is the norm.
Okay. Thank you.
I'm happy to answer
Appreciate
questions.
you coming down.
Thank you.
Thank you. Okay, next.
Good evening, Mr. Chairman. Mark Dix on behalf of the VCJC, and I have another member of the VCJC with me as well. And I think in answer to Senator Surville's question, the reason why it didn't deal with schools is this is supposed to deal with the interrogation of adult at a place of detention. And that's why the language that you see here was vetted by the VCJC. And just as a reminder, that's the criminal Boyd Graves is made up of 21 prosecutors, 21 defense attorneys, judges and justices from the Supreme Court on down. And so we would respectfully request your support for this bill. Thank you.
Okay, all right. College attorneys.
Well, Nathan Green, here on behalf of VCJC, as one of the prosecutors on VCJC, and we, obviously, this was with consensus of both the prosecutors and the defense attorneys there.
Okay, is there a motion? Any other questions? Okay, the motion has been made to report the bill, is a substitute, no, the bill. All in favor of the motion, vote aye. It says substitute, did we do that? Yeah, okay, we have it, all right. Motion has been made to report the substitute. All in favor, vote aye. All opposed, no. Okay.
Last one.
Ayes 11, noes 0,
Okay.
and 2 abstentions.
Okay, good.
So,
Now, you finish?
got one more.
Okay, where's that?
788 would increase the grand larceny threshold from $500 to $1,000. Okay.
All right, is there any, you've heard the bill to increase the grand larceny threshold from $500 to $1,000. Is there anybody to speak in favor of the bill? Administration?
Administration supports the bill, Mr. Chair. Thank you.
Okay, thank you. Anybody else? Coming up.
Mr. Chairman, Rob Bohannon, representing the Virginia Retail Merchants Association, speaking in opposition to the bill. Retail crime costs, shoplifting costs about $45 billion a year, average incident $559. Those are costs that retailers have to eat, and that go to their bottom line that hurt that as well. So all the other competitions out there.
Still a crime.
Exactly.
Okay, thank you. All right, next.
Dominique Martin, New Virginia Majority, we support.
Okay, anybody else want to speak for or against the bill? Is there a motion?
Move to report. Second.
It's been moved and seconded that the bill be reported. All in favor, vote aye. All opposed, vote no.
Ayes 8, noes 5.
8-5, the bill passes. I would like to, you don't have any more? Senator? Senator Obenshain has a bill that he thinks he can get through real quick.
Well, I hope so. I have, may I do it from here?
Yes,
Mr. Chairman?
please.
I have Senate Bill 1042, which is a elder abuse financial exploitation bill, deals with will contests and actually with a case that was decided by the Virginia Supreme Court. The case was Parsons. It was decided, I think, in 2018 and has created a rather challenging set of circumstances in which it's really, we think, fundamentally altered the way that that undue influence cases are proved in Virginia. The Wills, Trusts, and Estates section of the bar has worked with me and will continue to work on this. They do share some concerns, not that the Supreme Court got it wrong or anything, of course, but that it has set forth a standard that is going to make it virtually impossible for the family of a victimized elder to prove by circumstantial evidence that a will was procured by undue influence. For the lawyers on the committee, you will remember from law school or from your experience that in order to prove an undue influence case, it's a little like proving first-degree murder. They don't usually talk about it, and there aren't usually witnesses who'll say, yeah, he told me he was going to steal the estate. So you have to prove it by circumstantial evidence, and the rule has long been that if you prove that the maker of the will was mentally feeble, that a new will was procured by somebody who stands in a fiduciary or confidential relationship, and they procured a will that benefited them, and there was a prior contrary expression of their testamentary intent, then a presumption of undue influence arose. The Supreme Court in the Parsons case, though, said that presumption is a very fragile presumption that disappears with it's like a balloon that's blown up, and this is not my analogy, it's what the court said. It disappears like with a balloon with the prick of a pin, and that all that's necessary is for some evidence that this was the intention of the testator in order to prick that balloon and make that inference disappear. And that could be the testimony of a notary who may be lying, but that testimony, or a witness, one of the witnesses, who may say, they seem fine to me, and that's enough to eliminate the presumption. So what this bill does is, and eliminate the possibility of the jury being instructed of the presumption. What this bill does is says that if you establish those elements, those prima facie elements, that the jury shall be instructed that they may presume. So it basically takes from the court, once the prima facie elements of the presumption are proved, away the question of whether the presumption has been rebutted, and it gives that question to the jury. The Wills, Trusts, and Estates section agrees that there's a significant issue that needs to be addressed, that this may be the way to do it, and they have offered to continue to work with me during the course of the session, and I've agreed that if we cannot come up, I think this is a good solution. I wouldn't offer it otherwise, but if we cannot come to an agreement by the end of the session as this works its way through, unless it dies an earlier death, that I will ask to strike this bill and we'll continue to work together.
Okay.
I believe that this is the way to do it, but if the Wills, Trusts, and Estates section, I can't bring them along by the end of session, I'm going to move to strike
You're
this bill.
moving the bill to be reported, is that right?
Mr. Chair, can I ask a question?
Senator Deeds.
So I generally agree with the approach. I'm little, the term on line 15, mentally feeble. Is that defined in case law, or?
It is the term that the court has used for about 40 years.
Okay.
It used to be was old. And the
covers a
court
lot.
determined that there's a little much ageism involved in that, and that there has to be something more than being old. And the term mentally feeble is a term that's been utilized by the court for about 40 years.
I think it probably ought to apply to members of courts or judiciary after about 8 PM.
That's right. Okay, anybody else want to say anything? Okay, is there a motion that we?
I would move that we report this.
And second? Okay, all in favor of the motion, vote aye. All opposed, vote no. Okay. Louise, you go next?
Ayes 13-0. Yes.
Yeah, okay, all right. Senator Lucas, go ahead. So the bill has been reported 13-0. Senator Lucas has a bill.
Yes,
Joint
sir.
Commission on Healthcare.
Yes, sir, Mr. Chairman. If I can do it from here, I hope
Please do.
that will suffice. Okay, yes, Senate Bill 352, and I just want to say to you, Mr. Chairman, a lot of what I'm going to say is already in the bill, but the bill simply requires that guardians ad litem in their report to the judge shall address whether a guardian or conservator is needed based on evaluations and reviews conducted, and whether a supported decision-making agreement is a viable option in lieu of guardianship or conservatorship.
Okay.
Now, viability is an option based on determination of whether the person is cognitively incapacitated or not determined, or determination made by a judge during the hearing process in which evidence is presented by the guardian ad litem, parent, caretaker, or the individual with IDD. Guardian ad litem is required to, 1, visit the individual with IDD, and 2, consider all evidence and submit reports to the judge. And we have our director, Dr. Michelle Chesser, here, if you have any questions, because I understand that this got just a little bit off track a little bit earlier.
Well, Matt, Mr. Chair, if I could ask.
Yeah, Senator Deeds.
This is somewhat related to Senate Bill 585 from Senator Donovan we dealt with earlier. And I would just like for staff or somebody to explain how the bills work together, because I don't think, I don't remember what happened to Senator Donovan's bill.
Okay.
Yeah. What happened is that there were actually 6 policy options that were approved for this study. And we originally pre-filed 6 bills for those 6 policy options. After session began, a recommendation was made to create an omnibus bill that combines all of those 6 into one bill. So we went from having 6 patrons in the Senate to just 1. So what we have here is Senator Lucas moving forward with the policy option that was originally assigned to her. So therefore, the omnibus bill includes what Senator Lucas is advocating for in this bill.
And the only difference is if there's a need based on evaluation and reviews conducted, and whether a supported decision-making agreement is a viable option in lieu of the guardianship or the conservatorship. Everything else remains the same.
What I'm trying to understand, Mr. Chair, I think this bill was part of Senator Donovan's bill. Is that what you're saying?
Or vice versa?
Yeah, I mean, because basically, Senator Lucas's bill and 5 others were merged into one bill that Senator Donovan is carrying. So, yes, it is part of it. However, the fate of Senator Donovan's bill, the omnibus bill, is such that supported decision-making was removed entirely from the bill.
Mhm.
And now the omnibus bill only addresses guardianship changes to the guardianship code. So basically, Senator Lucas's bill is all we have left, frankly, to have something done to make people aware that supportive decision-making exists. And that's really all we're hoping to accomplish here.
Okay, any questions? It's been moved and seconded that the bill be reported. All in favor, vote aye. All opposed, vote, no, okay, strike the bill. All right, go
Mr. Chair,
ahead.
I'd like staff to, because that's not quite the way I understood it, but if Kristen could maybe speak to it, I'd appreciate it.
Well, Mr. Chairman, I think what happened with Senator Donovan's bill is that the supported decision-making was taken out. However, there was an enactment clause added to continue to study supported decision-making with DBHDS, and to continue the work that the Joint Healthcare Commission had completed over the course of last year. So Senator Lucas's bill contains language about supported decision-making. It seemed like the committee had made, or maybe Senator Donovan had made the decision that she only wanted to move forward with the guardianship language and not supported decision-making because she didn't feel like the supported decision-making language was ready. So Senator Lucas's language is the portion of Senator Donovan's bill that she had asked to send to DBHDS for study.
Well, that and many other of the policy options. It's not just option 3, which Lucas's bill represents.
Okay. Senator Deeds?
Well, Mr. Chair, Senator Lucas was not part of that discussion with Senator Donovan then? Is that?
No.
No, it was not.
Okay, all right.
So, Mr. Chairman.
Yeah, Senator Obenshain.
So you all endorse both Senator Lucas's bill and Senator Donovan's bill?
Mm-hmm. And that's
Okay.
not in conflict.
All right.
Except that the enactment clause on her bill.
The enactment clause would be for us to continue to study this next year, correct? Am I right about that? And
Yes.
by the way, I'm learning all of this
Yes.
basically today.
So are we.
It's been a long day.
Yes, ma'am, it has.
So, and we can do that, but it would be very nice if we could accomplish something during this session.
So you'd like this bill to be reported, right?
I would, very
Okay.
much so.
Is there a motion? Been moved and seconded that the bill be reported. All in favor, vote aye. All opposed, vote no. Okay, thank you.
Ayes 12, no 0, 1 abstention.
Ayes 12, no 0, and 1 abstention. The bill is reported.
Thank you.
Before we leave, this 851, I have 2 bills that I'd like to get out. We've talked about these kind of bills today. One is the closing the gun show loophole, since we have some people here on this issue. The voluntary background checks are required at the gun shows. This would make it mandatory. The state police are already at gun shows. There's no reason why we can't just make it mandatory if you're at a gun show. It's Senate Bill 543. That's all it does, is make it from voluntary to mandatory at gun shows. Background checks, the state police are already there. That's all it does. And if anybody'd like to speak in favor of it, that's all the bill does.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. If you look at the rate at which guns bought from dealers show up as the buyer is disqualified, it's about 1 in 120. If you look at the voluntary that took place, there were only 40 of them, but they found 1 person. So that's a rate of 1 in 40. It looks like if we had it mandatory, we'd catch a lot more people who are trying to buy guns at gun shows that are disqualified.
Okay, anybody? Laurie?
Mr. Chair,
Yeah.
Mr. Goddard, you'd also agreed that mandatory background check we passed last week would encompass this. Or 2 weeks ago.
If it stays alive, yes.
It would, yeah. Yeah, it may not pass. Go ahead.
Good evening, Lori House with the Coalition to Stop Gun Violence. We support the bill. Thank
Okay.
you.
Anybody with a different view?
Philip Van Cleve, VCDL. I think there's a reason that I like the system that we have now. It helps avoid indirect gun registration because the government doesn't really know which guns you have.
Yeah.
Thank you.
Okay, next.
Hi, good evening. Ed Skinner, Murray Skinner from Senate District 35. This is SB 543 is duplicative to the legislation that has been already under consideration here with SB 70. And so this is duplicative and could cause a lot of confusion. So I encourage you to oppose this bill. Thank you.
Okay, next.
Patricia Webb, Hanover County. You're trying to solve a problem that doesn't exist here. Less than 1% of the guns used in crimes have come from gun shows. There's not a problem. And there's no laws that are null and void at gun shows. So every law that applies outside of the gun show applies inside the gun show. Thank you.
Okay, thank you. All right, go ahead.
Good evening, John Pulliam, Fluvanna County. You're trying to solve a problem that doesn't actually exist. There's no gun show loophole. The point being is that there's already illegal for you to sell a firearm to somebody who's not allowed to have a firearm. It is becoming to the person selling the gun, to the person knowing well enough. So all this is going to do is encumber me from selling to my best friend or my brother or giving to my son a family heirloom. That's all it's going to do, because the gun show loophole is a myth. Doesn't actually exist. Guy can go around the back of the building outside the gun show and sell a gun. But it is against the law for him to sell it to someone who is a felony or not supposed to have a firearm. So, you know, you're trying to fix something that does not exist.
Okay.
You know?
Anybody else? Is there a motion? I move this
Mr.
bill be,
Chairman?
yeah, Senator Stanley?
I've asked this before, and I understand that my request to ask something to be passed by because I was in court didn't happen when it came to these gun bills. With the fact that myself and Senator Obenchain are the only ones sitting over here, and we have at least one who doesn't have a proxy here, I'd ask that this bill go by for the day.
Well, they can be here. We need to move these things along. I move that the bill be reported. And
We're also short SAS law, so.
well, I'm sorry. Okay. I move the
No,
bill
we
be
get a proxy,
reported.
He told me
Second. It's
text me
been
before
moved
he
and
left.
seconded that the bill be reported. All in favor, vote aye. All opposed, vote no.
Ayes 8, noes 5.
Ayes 8, no 5. The bill is reported. I have one other bill that we've talked about, and that is the minimum mandatory, Senate Bill 537, deleting minimum mandatory sentencing in Virginia. That's what we talked about that earlier. Sure. Yes. Well, we're still here. Is anybody who would like to speak in favor of the bill? I think we had some earlier people.
Mr.
And then we'll quit after this. Yeah.
Dominique, NVM again. We support removing all mandatory minimums. We know its impact with mass incarceration, how it disproportionately affects low-income and communities of color, and a host of other reasons like judges don't favor it even though it ties their hands. So for all those reasons, many more, we support that, and the ACLU echoes these sentiments.
And we have sentencing guidelines now too, making them unnecessary. Yeah, prosecutors.
Mr. Chairman, Eric Olson, Commonwealth Attorney in Stafford County, speaking for VACA. We oppose this bill. There's two components. There's the mandatory minimums for felony offenses, like use of a firearm in the commission of a felony. Those are there for a reason. In certain cases, this body has determined for good reason there should be a minimum sentence, and that wasn't happening, and it should happen, and it has been working. But I want to talk for a minute about the misdemeanors. Special victims, talk about second and third offense, second offense DWI, talk about DWI with an elevated BAC, things that are real problems and have a fundamental effect on public safety. DWIs is the one crime that has the most serious implications on public safety. If you don't prosecute those cases, if you don't investigate those cases well, if you don't prosecute them, then it has an effect on how many people die on the highway. Mandatory minimums are a way to make sure that the people that engage in that conduct know the consequences and actions, and they work.
Well, we have sentencing
Mr. Chairman.
guidelines though, too, right?
Sentencing guidelines are not in misdemeanor cases, sir.
Mr. Chairman.
Mr.
Yeah,
Chairman.
Senator Sherrill.
Sorry, I could not disagree more with you. Mandatory minimums have done a wonderful job of making me a lot more money than I would have made before. Because people have to hire lawyers and they're terrified, and they don't find out that they're facing jail time until after they've committed whatever they did. Most people stumble into them and don't realize that whatever they did had a mandatory minimum on it. But, Mr. Chairman, my concern is that I had a bill to study every mandatory minimum and ask the Crime Commission to look at them all to figure out which ones we ought to look at, to see which ones are effective or ineffective. And I think that's the better course of action rather than just to do a big blanket thing. And so I would move that we carry the bill over and send a letter to the Crime Commission to ask them to look at this along with my bill, which was the Rules Committee sent to the Crime Commission to be looked at. I think that's the better way to go.
Second.
Anybody else have anything to say? All right, moved and seconded, the bill be carried over for the year. Is that right? Any discussion? With the letter. All in favor of the motion, say aye. And vote aye. All opposed, no. Okay.
12 noes and 1.
Okay. All right. The bill is carried over for the year with a letter to the Crime Commission. All right, it is 8:59. Okay, 1 minute, Bill.
Property conveyance.
Property conveyance.
1094, is that, that's not a bill that has to go to finance, is it? They've not requested it. This involves a property overlap down in New River Valley, or New River Trail State Park in Pulaski County, and would just allow the Commonwealth to convey this guy down there less than 1/10 of an acre.
Mr. Chairman, I need to do a substitute just to clean up some of the, it needs a comma here, and it needs to spell out the word January and things like that, but nothing substantial.
Was an appraisal done?
Okay.
It conveyed for no consideration.
There's a substitute. Is there a substitute to the bill? Kristen?
I move we adopt the substitute.
Huh? Okay. All right. Is there a motion that we adopt the substitute?
I so move.
Is there a second? All in favor, say aye. Aye. Is there a motion that we report the bill as a substitute?
So moved.
All in favor of reporting the substitute to Senate Bill 1094, vote aye. All opposed, vote no. Thank you very much. Without any further ado, the meeting is adjourned until Monday morning at 8 a.m. There.